seek some time to file the memo in this jail appeal as well as an application for condonation of delay. Full stop. The prayer is allowed. This is the matter after a week on a date to be fixed. You want the date to be fixed or leave it to the registry?
I talk about the registry, my lord.
On a date
Much
to be
less.
fixed by registry. Okay.
The
We'll
problem.
how much is the delay? Jail appeal, we can take it liberally also.
Okay, my lord.
You
Much
file an
obliged.
application. No problem.
My lord, it was unlisted matter.
For bails.
No, my lord, criminal petition.
Okay.
May I, Your Lordship?
Hmm.
I beg to mention item number 29, Your Lordship. The
Right.
conducting counsel is out of station due to some health issues.
Achha, you're for the respondent,
Respondent number 1.
the insurance company.
Yes, Your Lordship.
Miss
SD Fille.
Learned Counsel for the sole respondent.
No,
Insurance.
no, 2 respondent are there.
Respondent number 1 seeks an adjournment. You have informed or
Yes, Your Lordship, I haven't.
seeks an adjournment on the ground of the leading counsel being unwell and submits that the appellant side has been informed. Prayer is allowed. List after
2 weeks, Your Lordship.
list after 2 weeks on a date to be fixed by registry.
May I, my
Yes.
lord? My lord, I beg to mention one criminal petition number 2 of 26, my lord, for withdrawal
To fix it
tomorrow, Your Honor. Yes,
Tomorrow.
yes, Your Honor.
Item number 1.
My pleasure. Well, this is a case of quorum non judice.
Of?
Quorum non judice.
Oh.
The cause of action, the contract
Mhm.
work was executed in Kurunkume district, Kurunkume district.
Mhm.
So then what had happened is, the agreement was also executed for at Koloreng in Kurunkume district. Now here, the village authority of the mall village in Naharlagan has assumed the jurisdiction.
Okay.
And secondly, my lord, both the petitioner here and the respondent, my lord, they resides in the town, my lord.
Okay.
That is under municipality.
So your basic contention is that the customary court did not have territorial jurisdiction.
Territorial jurisdiction. That is the case, my lord. So, my lord, will now I request my lord to indulge with the impugned judgment, my lord,
Yes.
passed by Naharlagan model blade.
Mhm.
That is page 31, my lord, by impugned order dated 26/8.
26/8.
26/8/2025, my lord. This is Papumpara district, my lord.
Mhm.
And model blaze, my lord, under the government notification comes under the blaze, my lord. So therefore, the definition of AP Civil Code, the territorial blaze customary code will come, my lord. So existence, my lord, there is no quarrel on this. Now, my lord, kindly come to page 43. Page 43. My lord, will see, my type copy, my lord, is at, my lord, if it is visible, my lord, I can
manage. 43.
My lord, kindly see the deed of agreement dated 29th day of July 2017 between so and so, Village Chaya, Logupa, P.O. Damin, P.S. Koloreng, under Kurunkume district, Arunachal Pradesh. And the respondent address, my lord, that is the petitioner case. And the respondent address is also, my lord, P.O. P.S. Kasi Parlo. My lord has seen this. I'm relying it, although we are denying this particular thing, my lord, deed of agreement. Now, kindly see, my lord, next page, my lord, will see. Page 44, my lord, will flip over, my lord. These are all these. There, one important point is, my lord, page 44, serial number 5, my lord, will come. That any kinds of disputes controversial arises out of the work shall be settled to the third party in consultation with the second party. Meaning thereby, my lord, the jurisdiction of the customary court is ousted here.
The kind of dispute shall be
Yes.
settled by, not really ousted. I mean, it will be something like ADR. They will consult and
Alternate
then,
dispute.
and then they will choose a forum, perhaps.
Correct, my lord. But then, prophesy, my lord,
Settled by third party in consultation with the
third
second
party is
party.
ADR, my lord.
Will be
It
settled
does
by
not,
the third
it
party in
excluded the
consultation.
jurisdiction of the village
In
authority.
consultation. It can be interpreted in more ways than one, it seems.
Correct,
You know,
correct, my lord.
will be as decided by, that would have been more clear. You know, what, if they meant that,
Correct,
if they meant something like ADR,
correct.
it could have been drafted in a more clear way that it will be, settled by a third party as decided by first and second party, something like that. But here it will be settled by a third party in consultation with second party. That means it will be decided by someone other than the two parties.
Yes.
And in consultation with the second party means that
There is,
he will be given an opportunity.
Correct.
He'll be in the process.
there is no
So
such
it does,
contemplation in this case.
then no, on the face of it, we cannot really say that they have chosen a particular forum,
Correct, correct.
or it can be interpreted that way also. Anyway,
Correct.
let's move on.
Now, my lord, see again at page 47. This is special power of attorney. my lord.
Mhm.
Once. So,
The contract was jointly given to two firms,
Two
right?
and then here, my lord,
And
next-
the petitioner, what is the name of the petitioner?
Lokam
His
Talu.
Lokam Talu
my,
is
here,
the
here, my address I am referring to.
Mhm.
The kindly see next, the second para, my lord,
second para of page 47.
page 47.
Okay.
It
Lokam
talks
Talu.
about my address.
Mhm.
My permanent hometown address is Coloreng, my lord. Damin, PS Coloreng of Kurumkume district, Arunachal Pradesh. And then I resides at Papunala, my lord.
Okay.
We can go.
And this person, the respondent?
Respondent is at Polo Colony. Well, just only for one, there is a notification which I could not annex, my lord. This Papunala excludes from the
Mhm.
pecuniary jurisdiction of the customary court, my lord. Here is a, my lord,
Hmm.
19 and 20, no extra judgment. Okay.
The impugn order, the impugn judgment is at page
Is page 31, my lord.
31 is the impugn judgment, right?
Correct.
Okay, 31.
Mm,
26/8.
Yes. So, my lord, kindly see the customary court of model place, Naharlagan.
Mhm.
Now, here the question comes whether this customary court has a jurisdiction or not. And here, my lord, 2005 guidelines, my lord, the pecuniary jurisdiction. There is a guideline, my lord. I will supply it.
But AFR, as per AFR,
Correct?
for indigenous people, the village authorities would have the jurisdiction. They have been empowered to try suits. Right?
That's why, my lord, this
Hmm.
contradicts with the,
Hmm.
my lord, kindly come to page 6.
Page
This is
6.
a guideline.
Page 6.
Yesterday also, my lord, in one matter,
Yes, yes.
my lord was dealing with this, but
Yes,
it was not placed, my lord. The power on civil justice, my lord.
Mm. Page 4.
Page 6, 7. No, page 6 and then clause 7, guidelines 7.
Page 6.
Guideline 7. Power of civil justice. my lord.
No. Powers on criminal justice. No, we are not on the same page. Power and responsibilities, head Gambura. You're on section
7.
7.
Yes.
Powers,
Guidelines,
yes, guidelines,
7A.
7. Okay, oh, yes. Power on civil justice.
Correct.
Yes.
Now, here what happens is, my lord,
Mm,
7A,
mm,
GVs shall try all suits without limit of value
mm.
in which both the parties are indigenous to the state and, my lord, there is a disjunctive, and
Live within the village.
live within the village. And
Mhm.
here, we, both of us are residing in a municipality area,
Mm.
which are excluded from their jurisdiction.
Village.
And number one. Number two is that the cause of action and the power of attorney, everything has been executed in Kurunkume district, my lord.
Hmm.
So from where they have assumed this jurisdiction. And thereafter, my lord, what had happened? Now, on the basis of this impugned judgment, my lord, on the basis of this impugned
The money suit was decreed, in a way decreed for amount of
5 crore.
5 crores.
Yes. So, my lord, they kindly come to ground 2, my lord. Ground 2 of my civil revision petition, page 15, my lord.
Mhm.
15. my lord.
Hmm.
For that, the impugned proceedings are without territorial jurisdiction, in as much as neither the petitioner nor the respondent number 1 is a resident of Maulal Blaze, Naharlagan, as is evident from the cause title of the impugned judgment itself. The petitioner is a resident of Papu Nala under PS Papu Hill, Capital Region, Arunachal Pradesh, whereas respondent number 1 is a resident of Polo Colony, Naharlagan, and is a permanent resident of Kurunkume district, Arunachal Pradesh. Admittedly, neither of the parties resides within the territorial limits of Maulal Blaze, Naharlagan, nor did the alleged cause of action arise within its jurisdiction. Consequently, the customary code of Maulal Blaze had no territorial jurisdiction to entertain or adjudicate the dispute.
Mm.
Now, my lord, that Kiran Singh judgment, my lord, Nikalo. My lord, I read ground 3 also, my lord, and then I rely one small judgment. For 16, my lord, page 16. For that, the customary code village authority, Kewang, of the Maulal Village derives jurisdiction only over dispute arising within its territorial limit or involving residents subject to its customary jurisdiction. In the absence of any territorial nexus with Maulal Village, the assumptions of jurisdiction by the customary court was wholly unauthorized, rendering the entire proceedings quorum non judice, void ab initio, and without any legal impact. In this regard, in the catena of judgments, the Honorable Supreme Court has consistently held that a defect of jurisdiction, whether territorial, pecuniary, or as to the subject matter, strikes at the very root of the court to pass any decree, and as such.
Subject matter jurisdiction strikes at the root. No
Strikes.
doubt about that.
So therefore,
Pecuniary may not always.
no. So therefore, the Kiran Singh-
That is there in CPC also, anyway. So,
Huh. My lord, I have these authorities with me. Which is it? Kहाँ से? अरे यार, Let me para 6 and 15. तो अच्छे से print करो. My lord is aware, it is a very old judgment. my lord. 1954 1 AC 710, para 5 and 16, my lord. If my lord permits, we read together para 6.
yes,
The answer to the contention must depend on what the position in law and is when a court entertains a suit or an appeal over which it has no jurisdiction, and what the effect of Section 11 of the Suits Valuation Act is on the position. It is a fundamental principle well established that a decree passed by a court without jurisdiction is nullity, and that its invalidity could be set up whenever and wherever it is sought to be enforced or relied upon, even at the stage of execution and even in collateral proceedings. a defect of jurisdiction, whether it is pecuniary or territorial, or whether it is in respect of subject matter of the action, strikes the very authority of the court to pass any decree, and such a defect cannot be cured even by consent of parties. If the question now under consideration failed to be determined only on the application of general principle governing the matter, there can be no doubt that the district court of Monger was a quorum non judice, and that its judgments and evidence decree would be nullities. The question is, what is the effect of section 11? That we are not going into. Valuation suit, valuation, my lord, this is relating to the.
This is 1954, of course. So it's a 1, 2, 3, 4 judges.
Valuation, the
Four,
fact,
four judges.
yes.
Four
Four.
judges, but the CPC also provides that some territorial jurisdiction objections have to be taken at the earliest, unless they will be taken to be waived.
Yes, yes.
Anyway,
Well, then also, my lord, will have the kind perusal of para.
but definitely there will be irregularity.
Yes.
Subject matter, of course, it goes to the root, absolutely.
Hmm.
But pecuniary and territorial will also make it defective,
Make it.
you know,
So
per se. It will make it defective. It will be
Yeah.
irregular at least.
now, my lord, kindly have this. Actually, my lord, see, this is a case born out, this is a case stem out of a contract dispute between two parties. Now, my lord, if we see the objective of the Civil Courts Act, my lord,
Mhm.
Civil Courts Act, my lord, the village authorities are only empowered, my lord, only empowered to deal with the PT civil cases and customary
People should be given the choice.
choice. So therefore,
I
here,
think that will be the position ultimately,
yeah.
that you can go to customary court if you are indigenous.
Correct.
Non-indigenous, the customary court has no jurisdiction. The indigenous people only can come.
that's why, my lord.
And they also have the jurisdiction, but the people, because yesterday also we saw that the Civil Courts Act enumerates the different civil courts. And after junior division is customary court.
My lord, kindly see the word customary court.
Hmm.
If we go by a strict interpretation
Hmm.
of the word customary court, is particularly to deal with the social issues, the PT social issues in the term of civil disputes.
Hmm.
But not the commercial thing, my lord. Otherwise, whatever the commercial court we are establishing, or the CPC or the regular civil court, the jurisdiction will be ousted, my lord. So that is one aspect of the matter, my lord. So now, my lord, has
Customary courts are also some kind of actually ADR in today's context.
alternative dispute
No,
resolution
that is
system.
because the main difference between a customary court, if I have not understood wrongly, is that the main difference between a customary court and a conventional civil court is that conventional civil court is adversarial mode, right? It's the adversarial mode, and the customary court is not strictly adversarial mode.
So, my lord,
Anyway,
see, ground 6 also, my lord, will come. Ground 6, my lord. For that, by assuming and exercising the powers of an inter-village customary authority, my lord, here, my lord, kindly see, at the first instance, the village authority, the respondent ought to have approached. Here they have gone for the inter-territorial, my lord, inter-village customary authority. At the first instance, the customary code of model village assert the jurisdiction not vested in it under law. Under the scheme of Assam Frontier Administration of Regulation 1945, an inter-village authority is intended to function only as an appellate or higher customary forum, not as a court of ordinary jurisdiction. Consequently, the impugn proceedings were conducted in excess of jurisdiction and in direct contravention of the hierarchical dispute resolution.
yeah, that's true. But I was studying the matter yesterday with regard to the other. The customary authority has been defined to include not just village council but also members of the inter-village authorities. Okay, and section 40 of the AFR says that the customary authorities would be empowered to try suits, all suits,
Unlimited.
unlimited.
So that's why, my lord, in one of my research,
So this aspect has to be, ultimately laid
Over-
down. Laid down. That
my lord, overlay.
per se, it appears that they also have appellate as well as some kind of original jurisdiction, especially if the persons belong to different villages. But this has to be ultimately
This is-
laid down by the court.
This is, my lord, I call it as a conflict of jurisdiction per se, overlapping of the jurisdiction with the regular civil code.
Mhm.
So, my lord, there in the ground 6, which I have said, my lord, I rely upon this judgment, my lord, Sushil Kumar Mehta, 1991 essay. It is there, my lord. I read out the paragraph, my lord. Yes, I read out the paragraph.
It's here.
It is there, my lord. In the compilation, it is there. Sushil Kumar Mehta, my lord.
Okay,
It is
got it, got it.
a reiteration of the Kiran Singh
Pa-
judgment.
Para.
Para 10, my lord. In
Okay. Yeah, mark.
In Kiran Singh versus Chaman Pashwar, the facts were that the appellant had undervalued the suit at rupees 2,950 and it in the court of the subordinate judge Mangur for recovery of possession of the suit lands and men's profits. The suit was dismissed and on appeal it was confirmed. In the second appeal in the High Court, the registry raised the objection as to valuation under Section 11. The value of the appeal was fixed at so and so. A contention then was raised by the plaintiff in the High Court that on account of the valuation fixed by the High Court, the appeal against the decree of the court of the subordinate judge did not lie to this court, but to High Court. And on that account, the decree of the district court was a nullity. Alternatively, it was contended that it caused prejudice to the appellant. In considering that contention at page 121, a four-judge bench of this court, speaking through Rama Iyer judge held. Now, this is what I said on the nullity, my lord. So therefore, my lord, all the consequential order, including the infirm Kaba judgment, may kindly be interfered with for time being and issue notice to the respondents, let them come. From a side, this is a quorum non-juris, my lord. It does not have the power.
The judgment was ex parte also.
Judgment of ex parte also.
We have to look.
Page 26 is by prayer, my lord. That may kindly be looked into. Para 14,
Just a minute.
the prayers.
Your main contention that this forum did not have jurisdiction
Correct.
was that the parties concerned are were not residents of
Model place.
model village.
And my lord, this Polo colony is just adjacent to our High Court.
Hmm.
It comes under the municipality and Papunala is also under the municipality. My lord, I have given a notification. You say. My lord, kindly see that notification. I have passed on a notification. My lord.
This one?
Yes, yes.
Guidelines,
No, guidelines.
not the guidelines.
There is another notification which I have given. 18 and 19 kindly see. This is municipality location, my lord.
Yes.
18 and 19, my lord. Polo colony and Papunala, my lord. Kindly see.
Localities within the municipal wards of Itanagar municipality.
So therefore,
Abu Nala and Polo colony.
correct. Therefore, my lord, the village authority does not have power. It's fine. Fine. Well, let's let it happen.
Yes.
Let the notice come go. State is represented by
You are seeking stay of this.
stay of this, my lord.
Yes, madam.
And also that
Anything
garnish-
from your side at this stage?
Your Lordship, in this matter, we are performer respondent, Your Lordship.
Your performer is.
Yes, Your Lordship, for two and 3 and 4, Your Lordship.
Third, T.T. Tar, learned senior counsel for the revision petitioner.
I am
was-
assisted by
was
Mr.
in-
Bab.
assisted by, was invoked the jurisdiction of this court under Article 227 of the Constitution of India against the judgment and order dated 26/8/2025, passed ex parte by the customary court of Model Village, Naharlagun, in money suit / complaint case number 1 of 2025, full stop. By the said judgment and decree, the revision petitioner was directed to pay amount of rupees 5,65,000. 500 to the respond number
One.
respond number 1. Who is stated to be the defendant in the proceedings before the customary court, but did not pursue the same, as a result of which the case proceeded ex parte. Full stop. Next paragraph. The primary contention of the learned senior counsel is that the territorial jurisdiction of the customary court of Model Village, Naharlagun, pertains to the indigenous persons of the said Model Village, Naharlagun, semicolon, various, both the parties being the petitioner and the respondent number 1 are resident of Papu Nala and Polo Colony, both of which are localities situated within the municipal wards of Itanagar municipality.
Corporate.
This still holds, huh? This-
Holds.
Full stop. In support of the same, the learned senior counsel has submitted 2025 guidelines for appointments of Gaon Buras in the state, and also a notification dated 1/6/2012 passed by the government of AP, indicating localities within the proposed municipal wards of Itanagar municipality. Full stop. Next paragraph. Referring to the decisions of ... I'll fill it up. You can write it from here. Okay. Referring to the decision of Kiran Singh versus Chaman Paswan, AIR 1954 SC 340, and the decision in Sushil Kumar Mehta versus Gobind Ram Bohra, 1991 SCC 193 dash, the learned senior counsel contains that the customary court assumed the jurisdiction which lay elsewhere, and therefore the order is liable to be interfered. Full stop. The learned senior counsel also praised for an interim order for not proceeding with the execution of the decree passed by the customary court. Full stop. In the 2025 guidelines, next para, mentioned above, section 7 pertains to power on civil justice, and section 7A thereof reads as follows. Just reproduce it, page 6.
It will be guidelines 7A.
Full stop. Yes.
Second.
In this context, the Learned Senior Counsel draws attention to the specific stipulation in the said guideline, and that the parties have to live within the village for the HGB and GB to have jurisdiction to try the dispute. I have also perused the municipality area notification and the serial number 19 and 22 pertaining to Papu Nala and Polo Colony is reproduced here in below. Lift. In the cause title of the judgment also, the address of the petitioner here in Lokam Talu is mentioned as being resident of Papu Nala, PO Naharlagun, whereas that of the respondent number 1, Ha Tatu, mentioned as Polo Colony, Naharlagun. You will accept notice? Yeah.
One.
Pro forma respondent.
3 and 4, Your Lordship. 1
3 and 4.
second party.
Lord Government Advocate,
Yes, Your Lordship.
Madam, accepts notice on behalf of respondent number 3 and 4, who in any case are the pro forma respondents. Full stop. The petitioner shall take steps upon respondent number 1 and 2. 1 and 2. Customary code also, you have to notice. Will they, is
no,
it
but not-
necessary?
No, but customary court, where there is a judgment by our division bench,
Mhm.
we cannot
Yeah.
narrate them as a part.
Any code we do not make usually.
We don't.
So we skip that.
Skip that.
The Learned Senior Counsel fairly submits that notice may be directed only upon respondent number 2 and respondent number 1, and that with regard to respondent number 2, though made a party, may be omitted for the moment. Accordingly, steps may be taken. You'll take by speed post. By speed post. Full stop. The petitioner is also at liberty to take dusty service, in which case and compliance affidavits shall be filed. Full stop. Upon perusing the materials and giving my consideration to the prayer for interim order, I am of the considered view that in the circumstances, the impugned, have they drawn up the decree also? Drawn up the impugned judgment dated 26/8/2025, passed in. What is the case number? Money case complaint we have written earlier. Is shall not be put into execution. Okay. Till shall not be given effect to, something of that sort. Shall not be put into execution or given effect to till the next date of listing.
Along with further proceedings in execution petition case number
Right.
01 of 2020
Okay, you can write that along with further proceedings.
pending before the
Execution case number
01 stroke 26
Still pending.
2026.
till the returnable date. But since it's a part, needless to say that the respondent, especially respondent number 1, upon appearance would be at liberty to
Correct.
seek variation or
Very fair,
modification
Very fair.
of the interim order. It's 3 weeks.
4 weeks.
Yes. Yes.
Let it be 3 weeks.
Fine.
List after 3 weeks. On let's fix a date. It will be convenient for you. 29. 1, 2, 3. We can fix it on straight away the next 19th August.
Yes, yes, I'm here.
Okay.
Obliged, Your Lordship.
Item number 2. Read slightly. Is also yours?
Yes, that impugned judgment and decree, my lord will find at page 22. my lord.
The similar matter? No.
No,
it's a
another
different
matter.
Right, appeal.
Here, my lord, what had happened? There is a place called Rose in Doimuk. And then the petitioner here is a Gambura, my lord.
Mhm.
And he has been made party. And the learned trial court proceeded with by making him as a party, which is not permissible in law. My lord, kindly see page 22, my lord.
Mhm.
I draw my lord attention to.
You are aggrieved by the appellate judgment. Mainly.
Yes, yes.
Just a minute. Let me see the operative order. Discussion, findings, title, appeal, disallowed. Okay. So he will not be prevented from cultivation
Yes.
in the land. No.
Now, my lord, kindly come to page 22. I want to point out one very important defect. How the learned trial court has committed serious.
This is the appellate court. This
Yes,
is the appellate judgment.
yes. My lord, kindly see post title.
Yes, sir.
So and so versus Chera Kecha, my lord. Gambura Village Rose, PO and PS,
Hmm.
Doimuk. Now, section 2, my lord. E and
Two.
3F
Mhm.
of the AP Civil Code defines
Need that, huh? Okay. Civil Code Act. Yes, defines.
it that defines customary court.
Hmm.
And these Gamburas, my lord, are appointed under section 45 of the 1945 regulations.
Hmm.
So therefore, they cannot be made as a party in any
Hmm.
process. I know this. 2E and 3F, my lord. ये तो judgment, हाँ, मेरा पास है.
The act, right? And
Correct.
3F.
3F and 2E, kindly see this one.
2E.
Yes. 2DD.
2021 Act.
Yes. 21 Act.
21 Act. 2E is Deputy Commissioner.
The 3E.
3E.
Oh.
Customary court. Yes.
Yes.
The classes of civil courts.
Classes of. Yeah.
Customary courts.
What our division bench says on this, my lord? On this ground.
Gamburas are included in customary court
Correct.
according to this.
According-
And as per our judgment, they cannot be made party.
They cannot be made.
Therefore, there's defect in this judgment.
First, made defect, my lord. But I'm reading along with this. I'll read ground number 1, and then I place this judgment, my lord.
In the suit also, where is the suit judgment?
I'll
the-
point it out. Let us read this first, and then I'll come to this judgment.
Just a minute.
My lord will have page 10 straight,
Para.
16.1, my lord.
Para 16.1.
16.1 is page 9, and 10 is the ground number 1, which I have raised it very seriously, my lord.
Para 16 point.
Page 10.
Page 10 of your
CRP ground.
yes. 16.
For
1.
1.
Hmm.
Page 10.
Right.
For that, although the respondent appellant arrayed the petitioner in the title appeal number 0321 by his name together with the description Gambura,
Hmm.
Blaze Rose, The learned court below failed to appreciate that mere edition of that description did not amount to impleading the Blaze Authority or the Blaze community as such, nor did it satisfy the requirement of representative impleadment under Order 1, Rule 8 CPC, where the relief sought and granted directly nullifies the binding effect of a resolution passed by the collective village public. Under the statutory scheme governing customary administration in Arunachal Pradesh, important, a Gaumbura presiding over a village assembly function as an official village authority customary forum, and a decision or the minute of meeting issued in such official capacity is in substance an institutional act of the village authority and the village community, and not merely a personal act of individual holding office. The learned court below, while ignoring the paragraph 16, this was raised in our written argument, my lord. I have annexed this. The learned court below, while ignoring paragraph 16 of the written argument on this score, proceeded to set aside the effect of the community resolution without the village community being represented or heard in its own right, rendering the appeal defectively framed and the relief granted thereon unsustainably to that extent. Now, my lord has seen this 3F, my lord, customary court. So, Gaumbura is a village authority, my lord. He has rendered a judgment in a judicial capacity, my lord. So, therefore, our division bench has clearly held, my lord. I have passed on. Kindly come to paragraph 8. It was by then His Lordship Ajay Lambat and Chief Justice. Incidentally, my lord, here the ASI who was investigating the matter was also made party.
Mhm. Yes.
My lord, we'll see this. Para 3 is important for us.
Mm.
I have taken judicial notice of the fact that petition has
No, you're reading para 3?
para 3 years for the fact, my lord, the proposition that I will be relying 8 and 9, my lord.
8 and 9.
Yes,
But
8, 9,
I-
and 10, my lord.
8, 9, 10. And we are reading 3 also.
Yeah, reading 3 also, my lord. Very interesting, my lord.
Okay.
I have taken judicial notice of the fact that the petition has been filed by one Sri Rahendra Baglari ASI,
Mm.
Jinja Police Station.
Mm.
The respondents in the petitions are Sub-Divisional Judicial Magistrate M. Munshi Milot, Biswanath Charali, who passed the orders impugned by virtue of this person, Gauhati High Court through Registrar General of Gauhati High Court, and Sri Amarendra Hazarika, who at the point in time when the impugned order was issued, was posted as Sub-Divisional Judicial Magistrate M in Biswanath Charali. It is therefore apparent that the read petition is directed against a judicial magistrate, my lord, who passed orders in his judicial capacity. Well, similarly here, now this impugned order is also, judgment and decree is also passed against the village authority, the respondent who is a Gaumbura, my lord.
He himself,
He-
the Gaumbura in his personal capacity has been impleted.
Implement. So
That is the main defect.
the main defect, my lord. The sub-divisional judicial magistrate has not only been impleted by designation, but also by name, so to impute personal action, my lord. Very unfortunate, my lord, this incident also. Now, my lord, kindly come. What,
Para 8.
para 8. My lord, kindly, may I request my lord to 6 also? 6, their lordship, his lordship has read out, relied on certain judgments. That Ajay Mukherjee, my lord, Anwar Hussain case, very popular case. my
No,
lord.
I like to
19
refer to.
Para 6, my lord.
Hmm.
At the outset, I would like to refer to paragraphs 9 and 10 of the judgment rendered by the Honorable Supreme Court of India in Anwar Hussain versus Ajay Kumar Mukherjee and others, AIL 1965 SC so and so, in context of provisions of Judicial Officer Protection Act 1850, the said paragraphs 9 and 10 read as under, my lord. In this appeal, the only question raised is that in ordering the arrest of the respondent, the appellant acted in discharge of his judicial duties, and he was on that count account protected by Judicial Officer Protection Act 1850. Section 1 of the Act, in so far as it is material provided, no judge, magistrate, or a collector or other person acting judicially shall be liable to be sued in any civil court for any act done or order to be done by him in discharge of his judicial duty, whether or not within the limits of his jurisdiction, provided that he at the time in good faith believe himself to have jurisdiction to do or order the act complaint if. 10, my lord. Next paragraph. The statute is clear, intended to grant protection to judicial officer against suits in respect of acts done or ordered to be done by them in discharge of their duties as such officer. The statute, it must be noticed, protects a judicial officer only when he is acting in his judicial capacity, not in any other capacity. But within the limits of its operation, it grants large protection to judges and magistrates acting in discharge of their judicial duties. If the act done or ordered to be done in discharge of judicial duties is within his jurisdiction, the protection is absolute and no inquiry will be entertained whether the act done or ordered or even illegal or was done or ordered without believing in good faith that he had jurisdiction to do or order the act complained of. If the act done or order is not within the limits of his jurisdiction, the judicial officer acting in discharge of his duties is still protected if at time of doing or ordering the act complained of, he in good faith believe himself to have jurisdiction to do or order the act. The expression jurisdiction does not mean the power to do or order the act impugned, but generally the authority of the judicial officer to act in matter. That's this alia has been. Now 7, my lord, is also very important, my lord. Here, para 7, 1992, that Savitri Devi judgment versus district. My lord might be aware of this judgment, my lord. Para 14, it has reiterated. Before parting with this case, it is necessary for us to point out one aspect of the matter, which is rather disturbing. In the read petition filed in the High Court as well as the special read petition filed in this court, the District Judge Gorakhpur and the 4th Additional Judge Junior Division Gorakhpur are shown as respondent, and in the special leave petition, they are shown as contesting respondents. There was no necessity for impleading the judicial officer who disposed of the matter in a civil proceeding when the read petition was filed in High Court, nor is there any justification for impleading them as parties in the special leave petition and describing them as contesting respondent. We do not approve of the course adopted by the petitioner, which would cause unnecessary disturbance to the functions of the judicial officer concerned. They cannot be in any way equated to the officials of the government. It is high time that the practice of impleading judicial officer disposing of civil proceedings as parties to read petition under 226 of the Constitution of India or especially petition under 136 of the Constitution of India was stopped. We strongly replicate such practice. So finally, this 8 and 9, all those paragraphs, finally it was set aside.
That's okay, I understand.
No, therefore, this is a fatal error the learned court below has committed. And second limb of my argument is, Lord, kindly see there.
The read petition was filed by the ASI.
ASI.
What
He cannot be impleaded in person.
contempt proceeding should not.
And then making our Registrar General and the Registrar as a party. They are very unfortunate.
No, sometimes in service matters and all, as you know too well. No, they can be because he's the administrative head of the court, but not in his that
in this
expression.
capacity.
That expression which you have used, that's a very apt expression in your petition.
Correct.
Institutional capacity, not personal capacity.
Not personal
Yeah.
capacity. Therefore, my lord,
I'm working in I pass orders in institutional capacity, not in a personal capacity. Otherwise, everywhere you have to be impleaded.
my lord, kindly just assisting, my lord. There is a Bangalore Judicial Convention, my lord. There in Bangalore Judicial Convention, it was fully decided. And the principle was laid how to protect the institution of judges. My lord. Otherwise, there is a fear, Damocles sword hanging on their heads, anytime it will fall. So no judge will able to deliver a fair judgment out of fear.
So this, the customary court had passed a rule in your favor, petitioner's favor.
No,
It was set aside by the
only there was a minutes of meeting, my lord.
minus of meeting.
My lord, no decree was passed, my lord.
Can we go to this thing? Will it be relevant to go?
I just,
That was challenged in the appeal
yes, my lord.
by the other side.
Title suit, my lord, I want to show something, my lord, in their,
Because this is the third forum, this
Yeah.
title appeal, so there must have been a
yes.
original civil matter.
Correct.
It is at which page?
My lord, kindly come to page 35, the appeal.
Oh, no, I just want to see the original order once.
Original order?
From which the appeal arose.
Okay, my lord,
Hmm.
page 22 onwards.
Just look, my notes of the meeting dated 8/4/21.
Right.
Chairman Shop. It is at which page? Can you help me?
Minutes, in our appeal, my lord, just,
In your revision,
here, I am
must have annexed that.
195, my lord, kindly see 195.
195.
Page 195. This is the minutes of the meeting, my lord. Marking what manner? And I just mark it.
Minutes of the meeting.
Yes. 195. This is the only thing, my lord. And here, my lord, I have
All the
acted in the
public,
capacity of GB Rose Village meeting chairman on the direction of the High Court and the SD only. Relief was granted beyond the pleadings.
Okay, so this was taken up in appeal.
Yes, my lord. A very unfortunate. This minute, my lord. And my lord, kindly come to their prayer.
Yes, Chairman.
Titles of the. And here, my lord, the learned trial court has granted relief beyond the pleadings, my lord. Page 52, my lord, will come.
No, I want to see the appellate judgment now.
Correct. They impugned the
Appellate. It is at which page? First,
onwards with the starts.
no, the appellate judgment. Where is the appellate judgment? Page number? I was just,
Come to paragraph 25.
I lost track, this. Where is the appellate judgment?
Appeal judgment does this impugn the judgment of degree.
Title appeal.
Yeah, title appeal.
Where is it? Page
That is, it starts from page 22. Page 20.
22?
Yes.
Okay.
Impugn judgment.
At the beginning.
Yes.
Sorry, I was here.
Normally, it will be like this only.
No. I was here and I just lost track. Oh.
Yeah. My lord, we'll see here.
Calling in
In the
question
course
the
title
legality
itself.
and effect of the chairman of the. Which have been noted that the author is filing for the district to tries to assess it. Okay.
Well, this is,
Chirake Chairman.
this is very
Hmm.
unfortunate.
Hmm.
The rest we will argue in the thing, but this is a fit case for interference. And Manoj, I want to point out one important thing, Manoj. Paragraph 43 of this judgment, Manoj,
Which judgment?
the impugned judgment.
Okay.
Judgment and decision.
Paragraph 43.
Yeah, Manoj. Page 33. Manoj.
Okay,
Okay,
Page 30. Page 33. Okay.
Hmm.
Para 43.
Paragraph 43 and 44.
43 is in the, it's an order.
Ah.
It's an order.
42, my lord, may I request my lord to come down to please pass to page 33.
Mm. Mm. Yes.
Point number 4 is there, my lord. He has interpreted the minutes
Mm.
in page para 41, my lord.
Mm.
The learned court below had interpreted
Mm.
the minutes 0804, which my lord had perused a while ago. And then now he clarifies again, there is a contradiction, my lord. It is clarified that this court has not finally adjudicated the titles or of the place community over the disputed land in this appeal. The decision is confined to the legality and effect of the impugned minutes of the meeting dated 0804/2021. Any person or party aggrieved by the earlier mail decision or the SDO order dated 12/06/2017 or otherwise claiming right, title, interest, or customary stroke community right over the land shall be at liberty to pursue the remedy available in accordance with the law before the competent forum. Para 43, Miller, where I have referred to, Miller. In view of above discussion, considerations and the findings, the title appeal number 01/2025 is allowed on contest. The impugned minute of the meeting dated 0804/2021 issued prepared under the chairman's signature, respondents raised so and so, Gambura raised, is hereby set aside and cancelled for the purpose of its binding effect against. Now here, my lord, he has gone beyond the jurisdiction, Lord. The respondent 44. The respondent shall not use the said minutes of the meeting that is 0804/2021 as an independent lawful authority to restrain the appellate from cultivation to dispossession or to alter the existing position of the land claimed by the appellant. The parties shall remain in peace and shall not take law into their own hands. Any change in the possession or enforcement of any rights shall only be in accordance with an order of the competent authority. He has given relief beyond the pleadings to us. Two things, Lord. This is not permissible in law.
All right.
I'll not burden.
Who are the respondents? Only one respondent?
Only one response.
Third, Gitara, learned senior counsel, appearing for the petitioner, assisted by full stop.
Please.
Next paragraph, the petitioner invoking Article 227 of the Constitution of India, read with Section 115 of the CPC 1908, is praying to quash and set aside a judgment and decree dated 22/6/2026 passed by the Learned Civil Judge Senior Division, UPA Papumpare, as appellate court in title appeal number 1 of 2025. It is stated that by the said impugned judgment, the appellate court set aside the minutes of meeting dated 8/4/2021 and restrained the petitioner from altering the existing position over the land in question. Full stop. The sole respondent is Sri Navam Muna. Full stop. The next paragraph, the brief facts contended is that one village meeting of Rose Village was convened pursuant to order dated 4/2/2021 passed by this court in WPC 755 AP 2017 regarding a land dispute of the village between the Taba Tanya and 41 others and Nabamuna and Nabambud. At page 194. The meeting was accordingly held on 8/4/2021 and Yeah. It was resolved, in the minutes of the meeting, it was resolved by 2/3 majority of the public of Rose Village that the land would be community land and no other individual would be allowed to claim or divide the land, and that the land would be kept for common purpose. Full stop. Next paragraph. Against the said minutes, the sole respondent herein, namely Naba Muna, preferred a appeal, as already mentioned above, being TA 1 of 2025, which was adjudicated and disposed of by the impugned judgment dated 22/6/2026, setting aside the minutes of meeting dated 8/4/2021, prepared with regard to Rose Village under the chairmanship of the petitioner herein, who is the Gaura of the said village. Full stop. The learned senior counsel submits that the appeal suffers from a significant error in as much as the petitioner who had signed the minutes of the impugned minutes of the meeting dated 8/11/2000, that give that date 8/4/2021 in his official capacity was personally impleaded as party respondent in the appeal, and therefore the said appeal was defective from the inception. Next paragraph. In support of his contentions, do we need to refer to this also? No. The learned senior counsel, referring to section 3 of the AP Civil Courts Act 2021, points out that customary court is mentioned as one of the civil court in section 3E. Full stop. The learned senior counsel refers to decision of this court, this was single bench.
Division bench.
Yeah, and decision of a single bench. Single. For Honorable Chief Justice as sitting singly.
Single.
Okay. Decision of this bench, of a coordinate bench headed by the then Honorable Chief Justice in writ petition 3057 of 2020. Full stop. In the said decision, in the said case, this court was adjudicating a writ petition filed by one police official who had made a judicial officer, being SDJM M of a district in Assam, as party in his personal capacity. Full stop. The learned senior counsel has taken this court through some of the relevant paragraphs of this judgment to contend that this court in Rahendra Baglari Supra, after discussing a few decisions of the Honorable Apex Court, disagreed and disapproved the act of impleading the head of the presiding officer of the adjudicating forum in personal capacity. Full stop. The writ petition was dismissed on that ground. The learned senior counsel submits that the said principles would be applicable herein as well. And therefore, the appellate judgment is defective and liable to be interfered with. Next paragraph. I've given my consideration to the matter. Issue notice upon the sole respondent. Steps may be taken by speed post. The liberty is also given for dusty service, in which case compliance affidavit shall be filed. The learned senior counsel seeks an interim order, at least till the returnable date. Consider the said prayer in the context of the submissions and the materials pointed out. Accordingly, it is directed that till the returnable date, only stay the impugned judgment. The impugned judgment in decree dated 22/6/2026 passed in TA, passed by the learned civil judge. You give that civil judge senior division UPR in TA 1 of 25 shall remain state. That's all.
I'm grateful.
List the matter after 3 weeks. After 3 weeks. You can choose a date. The other one,
But,
take another date that will be convenient for you.
After 3 weeks, just keep it 3 weeks.
3 weeks.
Yes.
No, since we are giving.
Fine. They will,
You write the same thing in the earlier as the has been passed exparded and liberty to seek modification vacation on. So the other one we had fixed it on
19th August.
19th.
Man, can you keep this open?
Mm.
Because after 19, I do not know where, sir.
Okay,
I
listed, list after 3 weeks, you make a mention.
Yes.
On a
Highly-
date to be fixed by registry.
Highly obliged.
Giving ex parte, that's why I thought I'd fix a date. Item number 3.
May I please, ma'am?
Yes.
My lord, by way of this application, my lord, the petitioner is praying for some protection in respect of the FIR which has been registered at Bandardeva. My lord, in this case, I'm not named in the FIR. There's no whisper about me in the FIR, my lord. But however, a notice under section 35(3) has been issued for appearance before the investigating officer.
What is the allegation?
Allegation, my lord, will find at page number 25, my lord.
Lordship, this is the connected matter originating of the same FIR, Lordship, at item number 15. So this matter may be taken together, Lordship.
That is for
In item number 15, CD was called for, Lordship.
CDS come.
Yes, Lordship.
Okay, then you can take it
To be taken up.
with 15.
50.
Yes, Lordship.
Grateful.
Item number 4.
3 and 4, Lordship, same.
No, same. Item number 5, 3, 4, 15, same.
May I please, your lordship? Lordship, I'm appearing through VC mode, lordship, in item number 5.
Okay.
Lordship, we have come praying for a protection under section 482 of the BNSS, lordship, for an anticipated arrest with regard to an FIR which is
Oh,
at
No counsel's name is reflected in the cause list. I think we'll have
lordship,
to direct.
lordship, right?
It's not shown. Your name is not shown in the.
Yes, lordship. In earlier occasion also the name was maybe it is not registered in the portal, lordship, because we have
Will-
filed the wakalatnama.
We'll direct.
Yes, lordship.
Mhm.
Lordship, the FIR is at
Let us
page
see the FIR.
16. Starts at 16. The relevant part will be page 19, lordship. It is with regard to certain
Uh,
page 19. 19.
Okay.
Lordship, if I found
Yes.
it.
Yes, I found it.
Yeah.
I'm on page 19, the FIR.
Yes, lordship. I'll read the FI, but lordship, the informant is the bank manager. I'll just indicate that at this initial part. I understand hereby lost
Government
this
is he is the bank manager of Apex Bank.
Apex Bank, near Julie branch.
Julie-
Actually, lordship, yes, lordship. They have deposited an FDR with the Eco Bank in 2015. An allegation is with regard to the
Yes, yes.
premature closure of that FDR in 2020, when the
Let us
petitioner
see
was,
the-
yes, lordship. I'll read
Hmm.
that, lordship. And,
I can read
I-
or
Yes, lordship.
Hmm.
I the undersigned hereby lost this FIR against one Sri Pranav Das. He is the bank manager and the branch manager of the Eco Bank Itanagar branch presently posted at so and so. On 8/7/2015, Apex Bank Nirjuli branch had placed a fixed deposit bearing so and so with Eco Bank Itanagar branch On 8/7/2025, I requested Ecobank to arrange for closure of the said FD, which on maturity amounted to rupees so and so. However, it was brought to my notice that Ecobank, without any authorization whatsoever from Apex Bank Nerjuli branch, prematurely closed the said fixed deposit on 15/6/2020. No written request, no authorization letter, no board resolution, nor any other form of consent or mandate was ever issued by Apex Bank Nerjuli branch for premature closure of the above mentioned fixed deposit. On 7/8/2025, I wrote a letter to Ecobank requesting confirmation of the closure of the said FD and the furnishing of the authorization, transaction details, internal approval, and audit trail, copies of communication, acknowledgement, or receipt. Pursuant thereto, by letter dated so and so, Ecobank Itanagar branch informed us about the status of the aforesaid fixed deposit. Upon receiving the said letter, it came to the notice of the undersigned that the fixed deposit so and so had been prematurely closed on 15/6/2020 without any authorization from Apex Bank Nerjuli branch. Despite this, the premature closure proceeds amounting to rupees so and so were illegally and dishonestly transferred to the individual savings bank account of Srimati Morik Pongong bearing account number so and so instead of being credited to rightful owner, that is the Apex Bank Nerjuli branch. Such action by the Ecobank, particularly by then the branch manager, amounts to criminal misappropriation and criminal breach of trust. The premature closure of the fixed deposit without authorization and diversion of the proceeds to the personal savings bank account of so and so indicates criminal conspiracy, dishonest intention to cause wrongful loss to the Apex Bank Nerjuli branch, wrongful gain to the accused person. I'll turn to page 20. I therefore request you to kindly register a case.
I've got it, no issues.
Lordship,
There was a request for prematurely closing the FD. Sorry, there was a request to
the allegation of not having a request and
arrange for closure.
yes, in
Arrange for
2025
closure.
of the
Okay,
FDR
but
in
it was
2000.
premature. It was request for closure was made, but it was closed prematurely.
Yes, Lordship. It was they came to know on 2025 that it was already closed in 2020, and at that point of time, the Apex Bank says they have not issued any request letter for closure. So now it has come to the Ecobank's knowledge in 2025.
It was transferred to the account of so and so.
So and so, yes, Lordship. And Lordship, thereafter the Lordship will come to page 20, the second paragraph. That would be really
No, I've
further.
read this.
Sorry, it is basically the dispute with regard to Apex Bank as a consumer keeping an FDR with the Ecobank. Now, Ecobank has internally investigated the entire issue and had found no fraud upon the bank manager or even the petitioner here in Lordship. Lordship will kindly come to the so-called at Annexa 5, Lordship, page 25. That is the charges on the petitioner, Lordship. It only says misconduct. There may have been some omission and commission on the part of the petitioner, but there is no element of any criminality with regard to the charges by the Ecobank, who investigated internally with regard to the allegation of fraud of premature closure.
Yeah, DP is proceeding against him.
Yes, Lordship, they
DP?
have started. Yes, Lordship, they have started. Not exactly. I only have the copies of the statement of allegation and the article of charges, and we are contemplating a reply, Lordship. Lordship will find it there is no allegation with regard to any criminality with regard to that. Only says there is a misconduct and commission and omission on the part of the petitioner, Lordship. And he was not named in the FIR, but the notice was issued because he was the clerk at that point of time, and that was his very first posting. We have approached his honorable court. The bank manager had approached, and he also got an interim relief, and he is again contemplated to appear on 3rd of August, Lordship. We will also appear on the same day if Lordship protects us. Lordship will find the order of the honorable coordinate bench at page 29. Similar FIR, only the bank manager who was named in the FIR has come.
Yes.
We are protected, Lordship.
Okay.
Lordship, only may I submit, Lordship, that there is a condition of intimating the IO. So that may be only intimation, Lordship. Earlier, we have requested his Lordship to only intimation. Otherwise, it was permission, Lordship, that shall not leave the state of Arunachal Pradesh without prior intimation. It may not be permission. It may be only intimation, Lordship, because otherwise he is serving in Bongaigaon at this point of time.
Intimation can be there.
We'll give an intimation when we leave after the statements recorded, but permission may be hers on the part.
You're Mr.
Similar-
Deka?
Yes, the Deka, Lordship.
No issues with regard to the interim, Your Lordship. The matter may be fixed along, tagged along with the
We'll do that.
82.
That is fixed on.
That is after 2
2
weeks,
weeks.
Lordship. No date was given, Lordship. So date may be given after 3rd of August. They're contemplating to appear on 3rd of August, Lordship. They've applied for the leave necessary for appearing.
We can fix a date also. You can
Yes,
you
Lordship.
can check your diary till while I dictate. And we can fix and it will come with that.
Yes,
right?
Lordship.
You can check your diary. Third, Mr. D. Deka, learned counsel for the petitioner, and Madam, your public
18, Your Lordship, additional people.
additional public prosecutor for the state. Full stop. Invoking 482 BNSS, the petitioner is seeking anticipatory bail in connection with Itanagar PS case number 131 of 26 under so and so section. Full stop. The case arose out of an FIR
Filed on 21/1/2026, registered on 13/5.
21/1/2026
Registered on
lodged by
13/5.
Rubu Gambo, branch manager of Apex Bank Nijuli branch. One Pranab Das, the then bank manager of UCO branch Itanagar, and one Morik Pongkon are named in the FIR. Full stop. The gist of the allegations is that on 8/7/2015, the Apex Bank Nijuli branch placed a fixed deposit and requested to arrange for closure of the same on maturing attaining the maturity amount of 17,45,215. It is alleged that, however, the UCO Bank without authorization prematurely closed the FD, and thereafter even the amount the amount was transferred to the account of FIR named Morik Pongkon. Full stop. When the matter was brought to the notice of the UCO Bank officials, they assured to look into the matter, but it has not been resolved. Whereupon the FIR has been filed. Next paragraph. The learned counsel submits that the present petitioner happens to be an employee of UCO Bank in discharging clerical duties, and that was his first posting in that.
Yes,
UCO
Lordship.
Bank.
Eco Bank Itanagar branch
You-
at the relevant point in
The
time.
UCO Bank.
Itanagar branch.
Full stop. Itanagar branch. Full stop. It is further drawing attention to the relevant document annexed. It is submitted that in the meantime, the petitioner is also subject of a disciplinary proceedings drawn up by the bank. It is submitted that FIR named accused Pranab Das, bank manager, was granted interim bail on 22/7/2026 in AB 83 of 2026. In case diary has been called for. The learned counsel makes similar relief. Next paragraph. Call for the case diary of so and so. Considering the various aspects of the matter, including aspect of parity, it is directed that same like this earlier order. In the event of arrest of the present petitioner in connection with this case, he shall be released on bail of ₹50,000 with one surety of like amount, subject to the satisfaction of arresting authority, subject to the conditions that he shall cooperate with the investigation, shall appear before the IO, making himself available for examination within 10 days.
Yes, Lordship, will come on 3rd.
In 10 days, he shall not hamper or tamper with evidence. He shall not leave the state of Arunachal Pradesh without prior intimation to the IO of the case, right?
Yes.
Yes, Lordship.
I have prior intimation. list this matter after, let us fix a date. Can you suggest me a date from your diary?
Any
Your
date.
suggested date? Or you can appear online also?
Yes, Lordship, any date will be convenient, Lordship.
When do you suggest, madam?
On 10th of August, Your Lordship.
List this
Yes, Lordship.
matter on 10/8/2026 along with that AB.
83.
Along
Lordship.
with that.
Highly obliged, Your Lordships.
Item number 6. These matters, how are they dealt with? Referring to the only date. Okay. No. That's all.
Lordship, this is a joint criminal petition filed under section 528 of BNSS. Taking quashing of Lemi PS case 02/2026.
Where is the FIR?
Yes, Your Honor.
FIR?
Yes, FIR dated 17/03/2026, which is registered under section.
Page 73? Yes.
Yes, Lordship. Page number 73 is complaint letter.
Okay, we'll issue notice and state. Okay.
Lordship, in the petitioner number 1 and 2, they are family relatives.
Yes, yes, I understand.
So
That's
Yes, ma'am.
issue.
Yes, issue
We
notice
should-
and may, part of proceeding maybe.
Yes, we should issue the notice, right?
Yes.
Lordship, there is an interim prayer also.
Yes, yes, I get it. I'm granting your interim pay. Okay. I'm granting your good name, please.
Estana.
A learned counsel for the petitioner, public prosecutor for the state. Additional PP, right? Additional PP for the state. The petitioner, the two petitioners herein
Yes.
are the accused and informant respectively.
Yes.
Of Lemi PS case number 2 of 2026. And they have mutually invoked the jurisdiction under 528 BNSS seeking quashing of the said criminal proceedings. Good stuff. It may be mentioned herein that the case was registered based on an FIR lodged by petitioner number 2 on 17/3/2026, alleging trespass, assault, and intimidation. Trespass, assault, intimidation, and threats. The accused is stated to be the cousin brother of the informant. The allegations are also made about physical and mental torture without valid reasons. Next paragraph. The investigation of the case resulted in a charge sheet and presently pending the case, and the case being GR 46 or 26 is presently pending before the learned CJM SEPA, East Coming District at SEPA. It is submitted that subsequently both the petitioners entered into an agreement amicably settling the dispute, and in the context of the same filed this petition for putting an end to the criminal proceedings. Issue notice. The copy may be furnished to the learned additional people. Call for the scan TCR of GR number so and so. From the learned code below. Full stop. In the circumstances, further proceedings of GR 46 of 26 shall remain state. in the next date of listing. This is the matter after,
My lord, let it be on 19, madam, after 3 weeks, 19th of August.
after 3 weeks on 19. Okay, obliged.
Obliged, my lord.
Matter number 7. After this, I'll take a break, 5 minutes.
Bed resolution.
Yes, sir.
Bed resolution. My lord, the prisoner, he is the director of some Odisha Police, Finance and Technology Departments. And who is the registered society, my lord, registered society, registered society. And they have got their own rules and regulations to be followed. My lord, at page 9, page 8, that is para 8 of page 9 of the petition, I have given the objectives. You'll also find
Page 9.
page 10. These are the objectives. Page 10, these are the objectives are to be followed by the department, my lord, regarding the promotion of science and technology, etc. And at paragraph 9, you'll also see section 7, all the powers and function of the rights and rights, whatever is or consequential incidental to carrying out the objective of the council shall be accessed or performed by the executive committee, in particular, without prejudice to the reality of the foregoing provision and subject matter. Make, amend, repeal bylaw relating to the administration and management of the affairs of the council. Thus, so they perform their own action within the rules. That is inappropriate. What has happened in this case, my lord? One RTI activist, my lord, he filed a complaint before the secretary, my lord, regarding promotion regulation, etc. and all this. Now, in pursuance to that complaint, my lord, there was an inquiry at that is at you'll also find Annexure 5, that is starts from but the relevant portion,
Page.
yes,
Oh, 5.
it's a big report, my lord. He has taken all the activities, etc. and all things, but you'll
Page
also
5.
find
Annexure 5.
as
Yes.
we are concerned with the criminal action, you'll also will find not the irregularities, but at page 47, you'll also will find this as vacant order.
47.
Page 47, my lord. Page 47. Illegal actions of the chairman and director comes member secretary for giving undue favor to so and so, and illegal appointment and regulation of the 13th district court without following any process of law. If gratification is proved, is liable to be. Now, there was no gratification, no abuse of process or taking of money, etc. Your lordship may now come to the FIR at page 21.
At page
21. Now this
yes.
FIR is filed under section 120P, 409, 468
FIR is filed by
for 13(2) PC Act. Now,
this.
the whole FIR is the complaint, etc. and all these things. And you also will not find any gratification. What is the loss of the money and who is the person involved in those activities? So, what
This is preliminary. Let me have a look at the preliminary inquiry. Complaint was lost by Manam Tapia.
they have named in this FIR, senior accounts officer to visit court, chairman, director, and 13 appointed district coordinator. Yes. Copy of the complaint, that is representative of original, that is so and so. Learn it to submitted 3 years so and so. Illegal regulation, illegal promotion, the POA director so and so. The finding during the inquiry, as I have said, my lord, no gratification of harm, gratification of it. That is a violation of law and implication irregularities. No.
So he recommended preliminary
Exactly.
inquiry recommended registration of a criminal case.
So, question is, my lord, if there is a line drawn, my lord, with a criminal code, that is a penal offense. With a civil code, there is a property dispute, and in the departmental action, they are different. But if there is no penal section involved, my lord, how else trial court can take jurisdiction of this matter?
What is the stage of the case?
My lord?
Investigation,
Yes, my lord, this under investigation.
under investigation.
So, my lord, this is a preliminary inquiry, my lord.
No, the case has been registered
Yes, my lord.
and investigation has started
Yes, my lord.
beyond preliminary. inquiry.
Yes, my lord.
So at this stage, notice, I think,
But
stay of investigation is a very
you also may.
high threshold, and as you know.
There is a full bench decision also, my lord.
The Niharika infrastructure
Say-
lays down a very high threshold for staying in. He's on bail. Is he on bail?
But, no, my prayer is that, my lord, that you also may examine the matter, issue notice, etc. But no coercive action, because what has happened in this case, my lord, these persons who are holding the post, my lord, with this FIR in position, my lord, there is a consequential effect on their service career, my lord. Because so long as the FIR remains, my lord,
No, that's true.
There is a-
But he's
they are.
no any DP against him? Any disciplinary proceedings against him? No. Again, any DP against the person?
No coercive action may be taken, my
No,
lord.
he's because instead of passing, since it's a ACB matter, right?
My lord.
Instead of passing that kind of a order here, he's at liberty to file a bail petition, which
My
can be considered on its merits.
My lord.
And when we are calling for the case there, he can file the bail earlier also. In that bail, if he gets anticipatory bail, good enough.
Yeah.
Otherwise, since if he was already on bail, then another matter, it was no problem. But since he has not filed a bail application, so in a quashing matter, because passing such an order, coercive, not taking in coercive order, that's also, anyway, so then, and Niharika, some guidelines have been given regarding coercive action.
My lord.
Anyway, that aspect I may have to discuss. But at this stage, we'll issue notice, and regarding coercive action, let me also look up the law, what the guidelines have been given regarding coercive action. Madam, please. Tika Das, your counsel. Assisted by.
Ticket us.
No, not you. Madam's
give it.
name, you also give your name. And Pada, learned public prosecutor, addition, special public prosecutor for the ACB, Arunachal Pradesh district. The invoking jurisdiction under 520 BNSS, the petitioner, namely so and so, is seeking quashing of the criminal proceedings being ACB PS case number 6 of 2026, which was registered based on an FIR dated 1/6/2026 under section so and so so and so. Full stop. It is stated that the special judge PCA UPR or Arunachal Pradesh is seized of the matter. The petitioner is stated to be an official of Arunachal Pradesh Science and Technology Council, right? A complaint was made against him on the administrative side first complaint was on the administrative side.
It's all the promotion etc. within the administration, my lord.
Hmm.
And according to law, according to the bylaws there.
Regarding anomalies in the
And if there is anyone else, my lord, that-
appointment and then regularization of some employees. Full stop. A preliminary inquiry was conducted, which returned some adverse findings with regard to the petitioner vis-a-vis the allegations, and also recommended registration of the criminal case. Full stop. Thereupon, the instant FIR was, who lost the FIR specifically?
FIR is lost by my lord.
Labam.
Money Kripa.
Labam, thank you.
Yes.
Mhm.
Labam,
Who's he? No, Nabam Taglo.
Labam, thank you.
Nabam Taglo. Full stop. No, sorry. This was the administrative complaint. This was the preliminary inquiry.
My lord.
Nabam Taglo. Anyway, subsequently the FIR was lodged before the Anti-Corruption Bureau of the state, leading to registration of the case. Full stop. The Mr. Das Learned Counsel submits that the matter pertains to, at best, some administrative irregularities and does not justify registration of the does not justify a criminal proceeding against the petitioner.
Though gratification is
Full stop. Even in the, it is submitted that even in the preliminary inquiry report, it is stated that provisions of the PC Act could be attracted if gratification is proved. Full stop. The learned senior counsel praised for an interim order at this stage by way of not subjecting the petitioner to coercive action. Full stop. It also transpires during the hearing that the petitioner has not yet moved any bail application for pre-arrest bail. Full stop. Mr. Pada, learned special public prosecutor, submits that the case is at the stage of investigation. Full stop. Accordingly, call for the update, call for the up-to-date case diary of this one. ACB case number was 6 of 2026 from the concerned police station. Scan copy will do.
My lord.
Scan copy will do. Full stop. In the case of Niharika infrastructure, the Honorable Apex Court has clearly indicated that the threshold for staying an investigation is rather high. And with regard to any directions, directions on the lines of preventing coercive action, also certain guidelines have been given. So I'll refer to that.
no coercive action also.
No, that I'll keep it open. I'll have to just go through the guidelines and keep it open. Lunchtime I'll complete. You take the date, please,
My
for
lord.
your convenience.
My lord, under the same FIR, my lord, today they have filed
Another petition.
an application.
So we'll pass common order.
Yes, ma'am.
Pass a
They
common
have
order.
mentioned it, my lord.
We call for the case diary and fix a date regarding coercive action. Just want to refresh myself with the guidelines given by Niharika infrastructure says that threshold for staying, usually investigation should not be stayed.
My lord.
But that coercive action matter has also been discussed in Niharika infrastructure. Some guidelines have been given. I'll just refresh once
My lord.
and then pass an order. Okay. It's common order and same date. Okay. Same date. When you can suggest a date as per your convenience. After a week or something,
The land senior counsel will
you
send.
can just give the date.
My lord.
We'll fix the date. List on so and so for case diary.
But I will
Before
take
to
Government advocate supposed to appear, my lord.
Otherwise also, my lord, they have basically challenged the 133 order, my lord.
I see. You are appearing as a public
As public prosecutor.
prosecutor. Who will appear for the district? You can represent?
Man, I can represent, no issue.
I think you can represent.
Yes, my lord, I can.
He can represent, right? So, any records?
Yes, my lord, records perhaps. My lord, initially, basically, my lord, we have raised an objection on maintainability in this case, my lord.
Okay.
Because, my lord, this is a final order, my lord. The 133 is a final order, my lord. Without affording the opportunity, final order was passed.
Mhm.
So now it's being impugned, my lord. They're supposed to invoke the revisional jurisdiction of this court.
Rather than
They have invoked 428, my lord, or 482, my lord, the inherent power.
the order was passed under 133.
133, my lord. That order culminate the end proceeding, my lord.
Mhm.
The final order.
Usually, yeah, that is true. Revision, you could have filed revision read with 482. You could have done that.
Yes, my lord. My lord,
Usually it is done like that only.
Yes, my lord.
Revision,
Yes, my
basically
lord.
as a revision.
Basic, my lord, it's a revision actually.
Section is also given of 482.
Yes, my lord. My lord, the interlocutory and the final order are in many cases, my lord, Supreme Court has dealt with, my lord. But now, my lord, what basically the practice is, they basically invoke for inherent power. What difficulty we face is, my lord, if the revision jurisdiction is invoked, there are certain, my lord, limitations are there. My lord, no, the limitation act will operate, my lord. There is a limitation for 90 days.
90 days.
But they circumvent the same by invoking the 482, my lord. Otherwise, it's a final order. And in fact, my lord, in their paragraph 12 itself, they have clearly, explicitly stated that it's a final order, my lord. They are not disputing that, my lord. And this issue was, my lord,
Nuisance, no?
yes, my lord. This issue was we have raised on the very first day itself, 7/5/24, my lord. The issue of maintainability was kept open by this honorable court.
Actually, as you know, sir, that one of the principles governing inherent powers
Yes, my lord.
is that when a specific provision is made in the code
Yes, my
for
lord.
the same,
Yes, my lord.
usually inherent powers are not needed.
Yes, my lord.
Right. So anyway, at least today we have to take a call on that issue,
Yes.
disposing of the matter.
Yes, my
So
lord.
today I'll just mention that you are Mr. Learned counsel for the petitioner. Full stop. The respondent number one state is represented by learned additional people. As per the office note, service upon respondent number 2/DM is Siang, Asigat is complete. They have not written anything, just said service complete. As per office note dated 24/2/26, long time. Service is complete. The learned additional PP undertakes to represent respondent number 2 as well.
Yes, ma'am.
Full stop. The petitioner herein has invoked inherent powers to challenge an order dated 30/4/2024 passed by learned DM East Siang under section 133 CRPC regarding illegal encroachment of government land and prohibiting construction and further directing eviction of any structure. Full stop. Next paragraph. The prosecution submits that there is an issue that the prosecution, the learned additional PP submits that whereas the petition is not maintainable in as much as the impugned order is a final order and if the same is sought to be assailed, comma, the same should be done invoking revisional jurisdiction.
Yes, ma'am.
Revisional jurisdiction. However, straight away invoking the inherent powers, jurisdiction on the inherent powers by a petitioner in such a situation allows the party to circumvent some of the restrictions associated with revisional jurisdiction.
Yes.
I'll just make your submission.
Yes, ma'am.
Be helpful later on. What kind of records we call for from the scanned copy of the case record?
Before the
was
district
called for-
magistrate, my lord.
Have we called for the case record or it has to be called?
It was not all from.
There's an interim order also.
Yes, my lord. Interim order is there, my lord. On the very first
The
day.
issue of, as per order dated 7/5/2024, the issue of the maintainability has been kept open. Full stop. I don't see any. This been pending for too long.
Yes, my lord. Too long. Since
Matters
2024, my
disposed
lord.
of. Actually, let's get the record and dispose it.
Yes, my lord.
The call for the scan case record of, what is the case number of this? There must be a case number, right? Where is the impugn order?
My lord, page 18, my lord, action number 2.
Yes. Call for the scanned case record pertaining to executive order dated 30 April 24, passed by the learned DM Isya. Reference, you give that memo number. Huh?
Yes, my reference number is there.
J-4303/18-19 within bracket PT. This would be sufficient, I think.
Yes, ma'am. That will suffice me.
The case record the scan record may be sent expeditiously. Should it remain in the admission column or we fix it for hearing?
Since we have raised on maintainability, my lord, issue on maintainability.
List on so and so in the admission column.
Yes, madam.
Interim order shall continue. That will continue once it's given. So any specific date or after?
Madam, after 3 weeks, no specific date required.
To be fixed by registry.
Obliged.
Obliged, madam.
Item number 9. Okay.
So therefore, we will rescue the city of Scotland.
Yes. What is SIC?
Earlier, my lord, it was
State.
shell.
Oh, now
Now
it's
it has become ACB.
okay. That's the right nomenclature. Respond number 2.
Now, my lord, why order dated, my lord, 1/7/2026, my lord.
Mhm.
There was a specific query from the Honorable Court, my lord.
Yes, sir. The first 2 FIRs have been amalgamated.
Yes, my lord, yes, my lord.
Amalgamated.
The specific query was that,
Now it is one case.
Now this one case.
This is, this,
Again, they file a.
so the petitioner is seeking quashing of the proceeding arising out of the third FIR.
Third FIR.
Now, in terms of that order, you were to take instructions whether the amount alleged in the third FIR comes within
Yes,
the earlier
The
proceeding. You are for appearing for the informant.
Number two.
Informant.
Informant. Now, I've received.
Who's the informant? He's a,
Takar Bagam.
Huh.
Takar Bagam, his name is.
okay, he's a private person?
Yes.
Private person?
Yes.
Mhm. Yes, please.
I've received the instruction, my lord.
Mm.
My lord, as per the instruction, my lord, and as per the specific query being made from the honorable court, my lord. It states that, my lord, the amount is same, my lord.
Amount is same.
Same, my lord.
The case is at the stage of, this is at the stage of investigation.
Yes, my lord. But the earlier two cases, my lord, after the investigation, my lord, the charge sheet has been already filed.
Don't you think it will be prudent to have a look at the case diary, whatever it is? There's already an interim order.
Yes, my lord.
Case diary has come,
The instruction has come, my lord.
instruction has
Yes.
come. Because they must have opened a new case diary
Yes, my lord.
since the case is under investigation.
Yes.
So on the basis of the instruction as well as the case diary, I think if it's the same, then probably the same kind of.
Therefore, my lord, in my humble submission, my lord, I may humbly pray that, my lord, this, they seek for watching the entire FIR, my lord. Like the earlier process, my lord, it can be amalgamated into the 16, my lord, so that we can keep it open, my lord, and if need be, my lord, we'll file a supplementary charge sheet, my lord.
Yes, that is always there. So investigating agency like the earlier case is agreeable to amalgamation.
Yes, my lord.
I think, okay, let me see the instruction and also you make any submissions from your side, madam?
No.
Today? Before I come to the learned counsel for the informant, let me have a look at the instructions. Where is the FIR of this one? At page? Where is the instruction? Instruction there to sign section. So it overlaps completely or
Completely.
completely? And then yes. I'll just go through and then come to you. 71 crores, 29 lakhs, and in this allegation, this particular FIR, the allegation is about the amount of
19.5.
19 crores.
Yes, ma'am. And 19 crore 50 lakhs 41,506 and 9 crores 55 lakhs 197 crores.
Can you get the case diary next week? No? That will be, the court will feel more complete passing order after having a look at the case diary. Otherwise, this is okay, comprehensive anyway. So 19 lakhs. This was the allegation. Yeah. It has been clearly stated, however, para 5. This is 13, right? Vigilance 13, case number 13.
Yes, madam.
And the original one was 9. The amalgamated one is 9.
2016. Ma'am.
Okay, that's fine. Mr. Rashid.
You can pick the next day then. Oh. You can talk to the CD so that can be able to.
The first FIR was filed by you only?
No, by somebody else.
Somebody else. Okay.
I filed only the last affair, third affair. In my affair, it is not only about the money also. There was allegation of giving false documents also, my lord. Because the loanee, he had given a document, landholding certificate, that was fake, my lord. During investigation, it has come to the light that that document he has obtained the loan by submitting that document. That document was forged, my lord. And the bank manager, what when after taking the, he had taken by giving that landholding certificate, he has taken two loans from that particular bank. One was for, I think the outstanding was around 19 lakhs, 50,000. The second was of around 9 lakhs 55, 9 crore 55 lakhs, something around 29 crores, my lord. After taking the loan, he didn't pay a single installment, my lord. He has defaulted. Then the proceeding started against the loanee, my lord. Thereafter, they took the entire proceeding before the look-at lot, and the loan was settled for around 10 crores and 6 crore, I think, was really. So total, the amount was settled for around 16 crores, my lord. The bank manager, he has waived more than 12 lakhs, my lord, or 12 crores, my lord. Thereafter, what had happened, then the in the look-at lot, the settlement was that the amount will be paid in 6 different installments, my lord. He didn't pay a single installment.
Even thereafter.
Even thereafter, my lord. And the banking manager within 3 days have issued a no due certificate to the loanee, my lord.
Despite non-payment.
In spite not payment. He was not authorized to issue that certificate also. During investigation, that has also come to light, my lord. Now, this affair, it is not only about the money, my lord. It is about the giving false documents and using that false documents as genuine, my lord. Even the bank manager, he was not authorized to issue that certificate, no due certificate, my lord. And that certificate has also been used as a genuine in different forums, my lord. That is the main allegation in the whole case, my lord.
So you think it's the if the amount is if the amount coincides, then it would be same as the previous affairs.
But
or you think there are facts which are
facts will be a little bit different, my lord, because here it involves the giving of certain documents which are false and using forged documents and using that forged document as genuine by the loanee as well as the bank officer, my lord.
Okay, it will be prudent to see the
Yes,
case diary, right? And while adjudicating this matter, we'll also need some materials pertaining to the earlier 2 cases. So is it annexed properly, all the FIRs, earlier 2 FIRs? Is it annexed? Because I don't want to call all the 3 CDs, all the 2 CDs. It will be 2 CDs now. So, okay. Would you like to get the second, the ACB 9 also? That also you can get. Okay.
Scan copy can be called for.
Oh, then it's okay. Then it will be most convenient. Most convenient. Heard, Madam so-and-so?
No, because it is already
Learned counsel.
filed, so you can get the scan copy.
And Mr. Ada, learned public prosecutor, additional public prosecutor, special public prosecutor, ACB or Arunachal Pradesh, and R. Gohai and
R. Sekhar, my lord.
R. Sekhar, learned counsel for respond number 2/informant. The petitioner herein is seeking quashing of SIC vigilance case number 13 of 24 under section so and so. Full stop. On the ground that the pertinent FIR dated 8/3/2024 has the same allegations as an earlier FIR dated. What was the earlier FIR dated? Earlier FIR dated ... on the basis of which SIC vigilance case number 9 of 2020 SI vigilance to case of 9 of 2024 is already pending. Full stop. It is submitted that a second FIR was filed, which was challenged by the petitioner by invoking inherent powers, and this court, by the order dated 4/3/2021, passed in criminal petition 29 of 2020, accepted the contention that the second FIR was on the same set of allegations, and it was and the second case registered was allowed to be amalgamated into special case number SIC vigilance case number 9 of 2024. The case of the petitioner herein is that a third FIR was filed of the particulars mentioned above, and on the same principles, the petitioner is seeking quashing of the proceedings pertaining to the purportedly third FIR.
Yeah, in my affair, the allegation is not against the petitioner. It is against the loanee as well as the bank manager only.
Only, yeah.
Only, yes.
Since the allegation is different, but the amount is different. Then there is no allegation against the present. Amalgamated. So the execution go on, but the allegation made by the.
Can it be amalgamated if it's on different facts?
Come, my lord, first. Let the case study come first, my lord.
Per se, that will be convenient, no doubt. But if there are additional materials, then it will be, it will be like a statement. Then statement. If it is treated like a 180 statement, 161 statement, then some additional allegations can also come. But if it's an FIR, then on different allegations, it has to be a different case, right? So anyway, the learned special PP has secured instructions in terms of order dated 37/2025 as to whether the amount alleged in the present FIR covers the amount alleged in the first FIR about illegal loan disbursement of rupees 71,29,01,045. Should I mention about the instructions or not say anything? Keep it open.
The next step is
Yes, yes. Mr. Shekhar, learned counsel for the informant, submits that in the instant FIR, the allegations are not really against the petitioner, but more with regard to the bank
as well as the loanee, my lord. The person who has taken the loan, my lord.
the loanee and
the person who has taken the loan, my lord.
and to one other person.
Yes, my lord. He is Hyang Mampi. He is the MLA, my lord.
Okay. The allegation is more against the loanee.
Yes. As well as the bank manager, my lord.
And the bank manager. Full stop. Nevertheless, upon a query by the court, the learned special PP undertakes to procure the scanned case diary of both the cases, being SIC Vigilance 13 of 24 and SIC Vigilance 9 of 24. And the order is reflected like that.
9 of 26, 16.
Oh, so it's very early. Sorry, That 9-1 will be of 2016 itself, very old case.
Yeah.
Investigation is still going on.
No, my lord.
Or charge sheet has been filed in that case. It is more clearly mentioned here. 9 of 2016. Yes. Full stop. It is submitted at this stage by the learned special PP that in the SIC 9 of 2016, charge sheet has already been made. Therefore, a scanned copy of the charge sheet shall also be procured. Charge sheet as well as case diary. You will take this back? Yeah.
Lordship, your lordship has not directed that FIR number 13 of 2024, the case diary should be called for, my lord.
Yes, yes. Both the case diaries.
Yes.
This 13 of 24 and 9 of 16.
Yes, madam.
Both are necessary. And would you like to file some affidavit or something incorporating this
That will be more
instructions?
prudent, my lord.
Huh?
That will be more prudent, my lord.
You
If
can.
affidavit is filed, my lord.
This is not a controversial thing. After inquiry, they found that the amount is same. Whether it will justify, that's another matter. Some other aspects are there. Mm. Mm. Mm.
Only with regard to the query, my lord, not on other aspect, my lord. Because other aspects are there already in the FIR, my lord. And that will be revealed
The
from
prosecution is at liberty to file an affidavit. I'll give you the liberty. Incorporating the instructions as mentioned above, full stop. In the alternative, the records pertaining to the instructions shall be produced again on the next.
Can a date be fixed, my lord?
Take it as per your convenience.
Monday? Yeah.
List after, when you can suggest
Next week, my lord, any date, any date.
next week.
Probably not possible.
Scan copy, no, say 2 weeks. Yes. List after 2 weeks. On, you can take a date then. 11 to 14 week you can take.
On 17, my lord, Monday, 17th August. Huh? Okay.
When do you, madam, when is it? Take you see your convenience also.
We'll inform the date, my lord.
Item number 10, you take back this, instructions.
My lord, I'm appearing for the sole respondent. My lord, we have raised the question of maintainability, and on the last occasion, the hearing of the maintainability was kept open. So, my lord, may we start with the question of maintainability? Because this is a petition under Article 227.
Right.
Sir, I will briefly state, sir, then you raise on maintainability. What exactly has happened? Then the issue will be dealt on maintainability, madam. To what, why, my lord, we have come before this court, madam?
This is the civil revision.
Yes, madam.
Civil revision.
Yes, madam. I am for the petitioner, my lord.
You are for the petition.
Yes, my lord.
And you are for the,
And for the sole respondent.
okay. For the sole respondent.
How this matter reach here, my lord, that has to be understood. Then, my
Just-
lord, the question of
Oh, yeah.
maintainability.
Let me have a look at the order.
If your lordship allow me, then I will.
I'll just come to you. Give me 2 minutes. Just. All right, okay. So now I will be in a better position. to-
Yes, my lord. In fact, my lord, on last occasion, perhaps is the part of the record, my lord. I provided the list of deaths, my lord, for better convenience of this court, my lord. List of deaths, my lord. Or my lord, this one, the same one, my lord.
No, it might be tagged also here. Somewhere inside. Find it. Okay. It's come up for admission. Are we taking it up for disposal?
My lord,
Or,
yes, my lord, disposal only.
or it will not be possible?
My lord, it's possible, my lord.
So let's see,
Yes, my lord, let's see, my lord.
let us see
Let us see.
as we move along.
Yes, ma'am. This is, my lord, the list of the,
You are for the petitioner.
yes, I am for the petitioner, my lord.
Mhm. Yes.
Initially, my
go
lord,
ahead.
actually what has happened on my lord, I will go chronologically, my lord. Later on, we'll come to the impugn judgments also, orders, my lord. On my lord, 21/7/2018, my lord, 2 LPCs were issued by the ADC Balijan in favor of the present petitioner for land measuring, my lord. This is the subject matter: 47,961 square meter and 49,066 square meter respectively, aggregating, my lord, the total area of 97,027 square meter, which constitute the subject matter of this dispute, my lord. This total, my lord, area is the subject matter of the dispute. Now, my lord, we are not on that, my lord. That is before the actually already, my lord, dealt by the village council, my lord. On, my lord, 11/8/2023, complaint has been lodged by this, my lord, the present respondent, the private respondent, for cancellation of both the LPCs, my lord. And subsequently, my lord, on 28/9/23, the ADC Balijan cancelled both the LPCs, my lord. So, and my lord, at the same time, the respondent has instituted, my lord, a complaint before the Gaupura Holongi, seeking, my lord, village council, invoking the APC, Arunachal Pradesh Civil Court, my lord, seeking for declaration of right, title, and interest over the suit land, the subject matter, whereupon, my lord, the notice was issued to us, my lord, to the petitioner. And, my lord, in the meantime, my lord, since the LPC was cancelled by the ADC Balijan, we being agreed, we prefer and read petition before this Honorable High Court, challenging the cancellation of both the, my lord, this LPCs, my lord.
Okay.
And, my lord, during the pendency of the writ petition, since the mail was, my lord, mail has issued, my lord, Parwana against me, the petitioner has intimated the
Pendency of writ petition before that.
Yes, my lord. We have intimated that there is a pendency of writ petition on that subject matter, LPC.
Okay.
So, in the meantime, my lord, on 24/10/23, my lord, the ex-party mail order was passed. Since I didn't contest, my lord. I was not there, although I have communicated. So, that is subject matter before the appellate court, my lord. Ex-party mail order was passed against the petitioner, my lord. So, being agreed, my lord, the petitioner prepared a civil appeal, my lord. Before, my lord, learned civil judge senior division, challenged the ex-party order dated 24/10/2023. That is the ex-party order, my lord. 24/10/2023, passed by the mail, and inter alia, my lord, seeking, we have also sought for, my lord, interim stay of the operation of the said order.
No,
my
no,
lord.
the ex parte order
Yes, my lord.
dated 24/10/2023 came to be filed during the pendency of the writ petition.
My lord, the writ petition, man, after that, my lord, writ petition was disposed of on the ground that, my lord, let the
Let it be decided by
yes,
the-
but my lord, since the mail order has already been passed, and it has a jurisdiction of civil court. So,
So
LPC
WP disposed of.
yes, WC 504,
Because
2023.
that is not mentioned, so I'm making a note.
Yes, madam. Yes.
So that's why otherwise it will not be clear.
Yes, madam.
So then
Now,
the
now it is in the session of the, my lord, civil court. The title is in, since it is the session of the civil court. my lord, the LPC is only the, my lord, the certificate which is supposed to be issued by the executive, but by the administration, my lord. But now, my lord, since the mail order was passed ex parte, my lord, we being aggrieved by the
You prefer the appeal.
yes, my lord, we prepare an appeal before the civil judge senior division.
All right.
And my lord, on 14/12/2023, my lord, the civil judge senior division pleased to stay the operation of the impugned mail order, my lord.
14 or 4?
4/12, sorry, 4/12/23, the operation of the mail order dated so and so
Was stayed.
it was stayed, my lord. And both the parties were directed to maintain status quo. Now, my lord, on 9/8/2024, my lord, the civil appeal was dismissed
For default.
for default on account of the absence of the petitioners, my lord, counsel on 3 consecutive dates. My lord, this is the issue here. 3 consecutive dates, that is on 9/3/2024, 14/5/2024, and 9/8/2024. My lord, the date of dismissal is 9/8/2024. The other, my lord, 9/3 and 14/2 are the previous absences, my lord. So taking into consideration this three consecutive absence, my
It was
lord,
dismissed for default.
dismissed for default, my lord. So, my lord, on after come to know about the, my lord, vacation of the stay order, my lord, it was come to know to the, my lord, the petitioner, present petitioner, on 5/1/2025, when, my lord, some unidentified individual allegedly, my lord, trespassing upon the suit land and threatened the petitioner mother and the farmer who were working there with dire consequences. At that point of time only, it was come to the knowledge of the petitioner that the status quo order was vacated, my lord, by the learned appellate court. So, my lord, on 6 itself, my lord, the FIR has been lodged. This is a matter of record, my lord, against the alleged criminal trespass upon the property, my lord, and assaulting petitioner mother and farm worker, making derogatory remark, etc., my lord. So, my lord, upon learning the appeal being dismissed on default and the status quo being vacated, my lord, and that too because of the, my lord, the counsel who was engaged on behalf of the petitioner, immediately, my lord, the petitioner has engaged a new counsel.
Okay, and
he filed an application, my lord, interlocutory application under order 41.
restoration of the appeal.
Yes, my lord, for readmission of the appeal, my lord. Order 41, Rule 9, under Rule 19, read with 151 of the CPC, my lord, seeking restoration of the appeal, along with a prayer for condonation of delay of 123 days, my lord.
But that was dismissed.
This was again dismissed, my lord. So now, my lord, on again, since it been agreed by the rejection, dismissal order, my lord, on 4/8/2005, the
4/8 was dismissed.
4/8 it was dismissed, my lord. On 27/8, this is
It was
declaration,
dismissed by the civil judge senior division.
senior division itself, my lord.
Right.
And, my lord, later, my lord,
Against that, you filed?
against we prefer, my lord, the miscellaneous application under section 104, read with order 43, Rule 1T
The code
of the CPC, my lord, before the learned district judge, UPR, challenging the impugned order dated 4/8/2025 and seeking for setting aside the same, my lord.
This is an appealable order?
Yes, my lord, my miscellaneous appealable order, my lord.
104.
I will come to the provision of the CPC also, my lord.
Section. Just a minute. All right, then order 43.
My lord, we will find in order 43, Rule 1T.
Order 43. Just a minute.
Yes, my lord.
Order 40. Order 43.
43, Rule 1T, yes, my lord.
1T.
Yes, 1T.
1T. ST.
May I read, my
An
lord?
order of
My lord, an order of refusal of Rule 19 of Order 41 to readmit or under Rule 21 or Rule 41.
Refusal to set aside the
Yes,
dismissal
ma'am.
orders.
So, my lord, we,
It will be a kind of FAO actually.
yes, my lord.
Mm,
So that provision has been invoked, my lord,
So-
and that was again again dismissed, my lord,
Again dismissed.
affirming the finding of the learned pars appellate court, my lord.
So you've come here.
Yes, my lord. Being aggrieved by that order, my lord, we have
Revision has been filed.
we have invoked the revision power under 227 of this honorable court, my lord.
We'll resume after lunch, Mr. Purtis. Have your lunch also. Okay. Oh, the records are here. All
Yes, record TCR already received, my lord.
after lunch.
Your Lordship, I beg to mention item number 28, Your Lordship.
Just make a mention. Item 28,
Yes, Your Lordship.
28,
Yes, Your Lordship.
criminal activity.
With question from all the parties, the matter will be listed on 28 August.
20. You are for the,
My lord, I'm for the petitioner.
uh,
The
who-
appellant.
for the respond,
No, for the appellant, my lord.
appel. You are for the,
Respondent number 1.
okay. On the request made by, you agree with
What the parties will.
learned counsels for both the sides. Mr. Matter is adjourned today, fixed on
28
28
August. August.
28th of August.
Yes, sir.
He's on bail
Yes.
No, he's not, my lord, he has been acquitted.
or
So
appeal
I
against
am the
acquittal.
mother of the victim,
Okay.
since my daughter was then minor,
Okay.
so we have challenged the acquittal.
No problem. Appeal against acquittal. Fixed on 28 of 28/8
28,
2026.
my lord.
Oblige, Your Lordship.
Highly obliged.
My lord, item number 24. This is for referral for the special
Yes,
petition.
these four matters.
Yes,
we need to take up.
my lord, this case is not going to be settled,
Mhm.
as by informed by the.
It will be settled
It could not be settled
or it
in,
could not be settled
mediation.
in
So,
the,
and this matter may be given to in a regular court.
so what orders need to be passed in this? Only referral to the uh, special mediation drive. Right? It will be, once it is referred, it will go to the Supreme Court.
No,
Right.
my lord, this is for mediation, referral for the
So this
mediation,
is not
special.
special local adalat. Settlement before Supreme Court or here? Sorry, these are High Court cases.
Yes.
Then it will go back to regular court. Sorry, I thought these are special drive
Oh,
of the local, the mediation which is taking place there. So these are High Court matters only.
yes, ma'am.
Also.
To be
You
fixed in
are
regular
Mr.
court.
You are Mr. Singh,
Mr. B.R. Das, my lord,
learned counsel for the
appellant.
appellant, submits that though efforts at mediation was made, but it was not successful, and prays that the matter may be reverted back to the regular court. Anything from the other side?
Anderson, my lord, there is no any other side is present, my lord.
The allowing the said prayer, the matter may be posted before the appellate court, that is this court,
Yes,
in regular usual course.
yes, ma'am.
Any date? No, not necessary.
My lord, date may be fixed,
List after 3 weeks,
2 weeks, my lord.
after 2 weeks on a date to be fixed by registry.
Yes, ma'am. My lord, and item number 26, this case is fixed for hearing. So I'm not ready for hearing today, my lord. In another date, maybe.
It's an old matter, however. Anyway, Mr. Das, learned counsel for the appellant, submits that he is not ready with the matter today to conduct the final hearing and prays for adjournment. Kindly inform the other side.
Yes,
Prayer is allowed. List on
2 weeks. Wait.
list after 2 weeks on date fixed by registry.
I have that.
Just a minute. Just 31. 31 is 1 month. 57. 56. Orders. All right. Okay, we resume that matter.
Yes, my lord.
Resume that matter.
And my lord, this was the writ petition, my lord, the dispose of matter, dispose of my lord order. My lord has a
So accordingly, in that backdrop, when this also, the prayer for vacation was also dismissed,
yes, my lord,
the
by the
miscellaneous appeal came to be filed.
yes, my lord.
And the miscellaneous appeal came to be dismissed by the.
Yes, same, my lord. The earlier order, Pars Appellate Court order was
And
affirmed, my lord.
this appeal has.
Yes,
come
my
to
lord.
be
And the finding of the learned Pars Appellate Court was, my lord, it's Pars Appellate Court influenced by the, my lord, the previous absence also, my lord. The two previous death and subsequently on 9/8/2024, it was dismissed, my lord, on default. But the learned appellate court was influenced by the earlier two previous absences also, my lord, which is not recognized by the law, my lord. That was the, my lord, order of the this honorable court in the writ petition, my lord, wherein due to pendency, my lord, during the pendency, by the time when the writ petition was pending, my lord, the petitioner had prepared for, my lord, Pars appeal before the civil judge senior division. Considering that aspect, the writ petition was closed, my lord, which was order was passed on, my lord, 23/10/24. Here, my lord, will find in para 5, having heard the submission by the learned counsel for both the parties, this court, considering the fact that the issue of ownership title of said land and property covered by LPC number so and so, for the plot of measuring so and so at Holongi is pending before the senior judge UPIA on appeal against the decision of customary court concerning the ownership of the said land and property. This court find that would be inappropriate at this stage to interfere with the impugn order dated so and so, by which the said LPC were recalled and cancelled. In view of the above, this court find that it would not be appropriate to pass any order either setting aside the impugn order dated so and so or make any observation regarding the ownership of the said land and property at this stage, considering the fact that matter is pending before the senior judge senior civil judge UPIA. Accordingly, writ petition so and so stand disposed of, and the observation made by this court above shall not have any bearing on the finding decision of the learned senior civil judge UPIA, my lord. This was the, my lord, the order of this honorable court in writ petition, wherein the LPCs were put into challenge the cancellation of LPC. And now the application, the miscellaneous application under 43 Rule 1T was also been rejected by the district judge, my lord, UPIA, my lord. On that count only, my lord, the trial or Pars Appellate Court rejection order was appreciated, affirmed, my lord. And the finding was on 3 consecutive days, the counsel for the litigant, for the applicant was remain absent. Remain absent, my lord. And the sufficient cause was shown that immediately, my lord, when he come to know about the dismissal of vacation of the status quo order, he has, my lord, hired and engaged a new counsel, and he has obtained all the record and immediately filed an application for restoration before the Pars Appellate Court, which was rejected on the count that on 3 consecutive days, the accused was remain, the counsel for the give sufficient cause for those 3 deaths, my lord. Although, my lord, the sufficient cause was supposed to be shown for the death when it was dismissed, not for the previous death. And my lord, the cause was that it was because of the default from the end of the counsel, my lord. That was the, my lord, basically the order of the learned appellate court, which was affirmed. And my lord, being agreed by the rejection order of this dismissal order of the district judge, my lord, we have approached this court by invoking, my lord, 227. Why, my lord? Because, my lord, may kindly come to section 115, my lord, the revision jurisdiction of the civil court, my lord.
Yes.
My lord, allow me to read out, my lord. 115. Yes, my lord. My lord, before that, my lord, the order of dismissal on default, my lord, it's not a decree, my lord, where appeal would lie, my lord. The specific provision has been provided under CPC for for recall of the same or for the, my lord, vacation of the same order or recall of the same order. So now, my lord, after being agreed, my lord, why 115 has not been, my lord, invoked, my lord? since this order is not a decree order. Now, my lord, 115, what revision says? The High Court may call for record of any case which has been decided by any court subordinate to such High Court, and in which no appeal lies thereto, and if such subordinate court appears to have exercised a jurisdiction not vested in it by law, or to have failed to exercise a jurisdiction so vested, or to have acted in exercise of jurisdiction illegally or with material irregularity. The High Court may make such order in a case as distinct with. Basically, my lord, revision deal with the jurisdiction of the subordinate court, wherein, my lord, the subordinate court failed to exercise its jurisdiction, and sometimes, my lord, exceeded its jurisdiction, and although exercised its jurisdiction, but committed illegality, my lord, which is apparent on the face of the order or the record itself. Now, my lord, here, my lord, why we are barred from 115 is the proviso, my lord, which has come to be inserted after.
So this proviso does not apply.
Yes,
No.
my lord, this
So it
proviso
was-
apply in our case.
Yes.
Because, my lord,
If the
reversal,
order was made in your favor.
yes, then it will culminate the proceeding before the
Yes.
trial court.
Right.
So reversal of the order will not at all affect the trial before the, in fact, it will make the, my lord, the pending, the court which has been dismissed for default will, my lord, revive, my lord. Then the court will proceed according to the merit of the case. Now the proviso says, provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in course of suit or other proceeding, except, my lord, where the order, if it is may have been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding. This bar us from, my lord, invoking this 115, my lord.
Because it does not apply to you.
Yes, my lord. Now, my lord, since because of this reason, my lord, this proviso, my lord, bar us from, my lord, invoking 115. My lord, we have invoked
Because
227.
if the order was made in your favor, it would not have ended the proceeding. It would have revived the proceeding rather.
Yes, my lord. Yes, my lord. If suppose this court pass an order in our favor in exercise of 115, then that, or because of that order, the proceeding pending before the order which we have challenged, the proceeding will be culminated. That has to be culminated if if revision is maintainable.
Got it.
But now, my lord, why? Since, my lord, this revision is not, we cannot invoke the revision because of this proviso. The 227, this is supervisory power of the High Court. Again, that supervisory power always lie. So now, my lord, to that extent, my lord, the supervisory power of the High Court has been discussed in, my lord, not this one. My lord, dealt in, my lord, this Surya Dev Rai case, my lord, wherein, my lord, the jurisdiction of 227 as well as, my lord, 115 has been dealt by the Honorable Apex Court. I will rely this judgment. At the same time, my lord, if I'm relying this judgment, I have to rely, my lord, the Radheshyam also, because to some extent, my lord, the Surya Dev Rai has been, my lord, overruled. Only to the extent that the judicial order passed by the court is not amenable to the root jurisdiction under 226. But it can be, my lord, revisable under statutory appeal or 227 of this Honorable High Court, my lord. Now, this is the, my lord.
Surya Deva.
Yes, my lord, Surya Dev Rai, my lord. I will rely on, my lord, from para 4, 5, 20, 25, 28. My lord, I will read, then I will go on to that. My lord, case was reported in 2003, 6 SCC 675, my lord. Now, my lord, I will directly go to para, my lord, 4, my lord. My lord, may kindly come to para 4, my lord.
Just
Earlier, my lord, there was no any proviso as such, my lord.
yeah, it was brought in by the 2002 amendment.
Yes, my lord. So they
shorten because the whole thrust of the
yes, my lord.
2002 amendment was to speed up civility.
Yes,
Which is
basically,
very correct.
otherwise everybody rush to the court and they get stay and the proceeding get stalled, my lord. For that reason, my lord, this was
Para,
my lord, from 4, my lord. I will read 4, 5, then 20, 25, my lord. I will mark it, my para 4, my lord. Section 115 of the Code of Civil Procedure, as amended, does not now permit a revision petition being filed against an order disposing of an appeal against the order of the trial court, whether confirming, reversing, or modifying the order of injunction granted by the trial court. The reason is that the order of the High Court passed either by way would not have the effect of final disposing of the suit or other proceedings. The exercise of revisional jurisdiction in such a case is taken away by the proviso inserted under subsection 1 of Section 115 CPC. The amendment is based on Malimat Committee's recommendation. The committee was of the opinion that the expression employed in Section 115 CPC, which enable interference in revision on the ground that the order, if allowed to stand, would occasion a failure of justice or cause irreparable injury to the party against whom it was made, left open wide scope for the exercise of the revisional power with all type of interlocutory order. And this was substantially contributing to a delay in disposal of the case. The committee did not favor denuding the High Court of the power of revision, but strongly felt that the power should be suitably curtailed. The effect of the erstwhile clause B of proviso being deleted and a new proviso have been inserted is that the revisional jurisdiction in respect of an interlocutory order passed in a trial or other proceeding is substantially curtailed. A revisional jurisdiction cannot be exercised unless the requirement of provision is satisfied, my lord. The requirement of the provision. Now, 5 says, my lord, as a prelude to search for answer to question posed, it becomes necessary to recollect and restate a few well-established principles relating to the constitutional jurisdiction conferred on a High Court under Section 226 and 227 of the Constitution in backdrop of the amendment Section 115 CPC. Now, my lord, may kindly come to para 20, my lord. Para 20, my lord. Authority in abundance is available for the proposition that an error apparent on the face of record can be corrected by certiorari. Now, my lord, later on, my lord, I will come to that. Expect the read of read 226, my lord. Corrected by certiorari, the broad working rule of determining what is patent error or an error apparent on the face of the record was well set on a Satya Narayan Lakshmi Narayan Hegge versus Mallikarjun Bhavnappa Tirumale. It was held that the alleged error should be self-evident. An error which need to be established by lengthy and complicated argument or an error
Such an error.
in a long draw process of reasoning on point where there may conceivably be two opinions cannot be called a patent error. In a writ of certiorari, the High Court may quash the proceeding of the tribunal authority or court, but may not substitute its own finding or direction in lieu of the one given in the proceeding forming the subject matter of certiorari. Now, my lord, may kindly come to para 25. No, citation. Okay. 2003-6. 36 SCC 675. Now, para 25. Upon a review of decisions and a survey of the occasions wherein the High Court have exercised jurisdiction to command a writ of certiorari or to exercise supervisory jurisdiction under 226 in the given fact and circumstances is a variety of cases. It seems that the distinction between the two jurisdictions almost obliterated in practice. Probably this is the reason why it became customary with the lawyers leveling their petitions as one common under Article 226 and 227 of the Constitution, though such practice has been deprecated in some judicial pronouncement. Without entering into the niceties and the technicalities of the subject, we venture to state the broad general difference between two jurisdictions. Firstly, the writ of certiorari is an exercise of its original jurisdiction by the High Court. Exercise of supervisory jurisdiction is not an original jurisdiction, and in this sense, it is akin to appellant, revision, or corrective jurisdiction. Secondly, in a writ of certiorari, the record of the proceeding having been certified and sent up by the inferior court or tribunal to the High Court, if inclined to exercise its jurisdiction, may simply annul or quash the proceeding and then do no more. in exercise of supervisory jurisdiction, the High Court may not only quash or set aside the impugned proceeding, judgment, or order, but it may also make such direction as fact and circumstances of the case may warrant, may be by way of guiding the inferior court or tribunal as to the manner in which it would now proceed further, appraised or comments or guided by the High Court. Now, matter 227 jurisdiction, it says, in appropriate case, the High Court, while exercising supervisory jurisdiction, may substitute such a decision of its own in place of impugned decision as the inferior court or tribunal should have made. Lastly, the jurisdiction under 226 of the Constitution is capable of being exercised on a prayer made by or on a behalf of the party aggrieved. The supervisory jurisdiction is capable of being exercised suo motu as well. Now, my lord, may kindly come to para 28, my lord.
Go ahead.
Para 28, my lord. May I read, my lord? Later, a two-bench of this court in Baby versus Travancore, Devawam board clarified that in spite of the revisional jurisdiction being not available to the High Court, it still had power under Article 227 of the Constitution of India to quash the order passed by the tribunal if the finding of the court had been arrived at by non-consideration of the relevant and the material document, the consideration of which could have been led to opposite conclusion. Well, these are the powers, my lord, the Supreme Court reiterating, my lord. This power of the High Court under the Constitution of India is always in addition to the revisional jurisdiction conferred to it. Now, my lord, para 29. And it says, heading, my lord, does the amendment in section 115 CPC have any impact on the jurisdiction under Article 226 and 227? Para 29. The Constitution bench in L. Chandra Kumar versus Union of India dealt with the nature of power of judicial review conferred by Article 226 of Constitution and the power of superintendence conferred by Article 227. It has held that the jurisdiction conferred on the Supreme Court under Article 32 of the Constitution and on the High Court under Article 226 and 227 of the Constitution is a part of basic structure of the Constitution, forming it integral and essential features which cannot be tempered with, much less taken away even by constitutional amendment, not to speak of a parliament legislation. A recent division bench decision by the Delhi High Court in so and so, in Govind versus State so and so, make an depth survey of decision cases, including almost all the leading decision by this court, and hold the power of the High Court under Article 226 cannot be whittled down, nullified, curtailed, abrogated, diluted, or taken either by judicial pronouncement or by legislative enactment or even by amendment of the Constitution. The power of the judicial review is an inherent part of the basic structure and it cannot be abrogated without affect the basic structure of the Constitution. The essence of the constitutional and legal principle relevant to the issue at hand has been correctly summed up by the division bench of the High Court, and we record our approval to the same, my lord. Now, my lord, may kindly come to para 34. May I read, my lord? We are of the opinion that the curtailment of revisional jurisdiction of the High Court does not take away and could not have taken away the constitutional jurisdiction of the High Court to issue a writ of certiorari to civil court, nor in the power of superintendence conferred on the High Court under 227 of the Constitution taken away or whittled down. The power exists untrammeled by the amendment in section 115 CPC and is available to be exercised subject to the rule of self-discipline and practice which are well established. Now, para 35. We have carefully perused the. Now, para 37, my lord. 35 is not relevant. Para 37, my lord. The above quoted sentence from Ganga Saran case cannot be torn out of the context. All the full bench has said in what, while exercising certiorari jurisdiction over a decision of the court below, refusing to issue an order of injunction, the High Court would not, while issuing a writ of certiorari, also issue a mandamus against a private party. Article 227 of Constitution has not been referred by the full bench. Earlier in this judgment, we have already pointed out the distinction between 226 and 227 of the Constitution, and we need not reiterate the same. In this context, we may quote the Constitution bench decision in so and so as also a three bench decision in so and so, which have also held is no uncertain term, as the law has always been that the writ of certiorari is used against the act or proceeding of judicial or quasi-judicial body, confer with power to determine question affecting the right subjects and obliged to act judicially. We are therefore of the opinion that the writ of certiorari is direct against the act, order, or proceeding of a subordinate court. It can even exercise if the lease is between two private parties. 38. Such like matter frequently arise before the High Court. We sum up our conclusion in a nutshell, even at risk of repetition, and state the same as hereinunder. 1. Amendment by Act 46 of 1999 with effect from 1/7/2002 in section 115 of Code of Civil Procedure cannot and does not affect in any manner the jurisdiction of the High Court under Article 226 and 227 Constitution of India. 2. Interlocutory order passed by the court subordinate to the High Court against which remedy of revision has been excluded by CPC Amendment Act 46 of 1999 are nevertheless open to challenge in and continue to be subjected to certiorari and supervisory jurisdiction of the High Court. 3. Certiorari under section 226 of the Constitution is issued for correcting gross error of jurisdiction, that is when a subordinate court is found to have acted without jurisdiction by assuming jurisdiction where there exists none, or in excess of its jurisdiction by overstepping or cross the limit of jurisdiction. 3. Or act in flagrant disregard or law of or the rule of procedure by acting in violation of principle of natural justice where there is no procedure specified and thereby occasion failure of justice. 4. Supervisory jurisdiction under Article 227 of the Constitution is exercised for keeping the subordinate court within the bound of their jurisdiction when a subordinate court has assumed a jurisdiction which it does not have, or has failed to exercise a jurisdiction which it does have, my lord. This will come in our case. Or fail to exercise jurisdiction which it does have, and the jurisdiction, though available, is being exercised by the court in a manner not permitted by the law, and failure of justice or grave injustice is occasioned thereby, the High Court may step into exercise its supervisory jurisdiction. 5. Be it a writ of certiorari or writ of supervisory jurisdiction, none is available to correct mere error of fact or of law unless the following requirements are satisfied. The error is manifest and apparent on the face of the proceeding, such as when it is based on clear ignorance of or utter disregard to the provision of law, and a grave injustice or gross failure of justice has occasioned thereby. 6. A patent error, an error which is self-evident, that is, which can be perceived or demonstrated without involving into a lengthy or complicated argument or a long draw process of reasoning, where two inferences are reasonably possible and the subordinate court has chosen to take one view, the error cannot be called gross or patent. 7. The power to issue a writ of certiorari and the supervisory jurisdiction are to be exercised sparingly and only in appropriate cases where the judicial conscience of the High Court dictates it to act lest a gross failure of justice or grave injustice should occasion. Care, caution, and circumspection needed to be exercised when any of the above two jurisdiction is sought to be invoked during dependency of any suit or proceeding in a subordinate court, and the error, though calling for correctness, is yet capable of being corrected at the conclusion of the proceeding in an appeal or revision paper thereagainst, and entertaining a petition involving certiorari or the supervisory jurisdiction of the High Court would obstruct the smooth flow and or early disposal of the suit of proceeding. The High Court may feel inclined to intervene where the error is such as, if not corrected, that the very moment may become incapable of correction at later stage, and refusal to intervene would result in travesty of justice, or where such refusal itself would result in prolong of its lease. The High Court 8. The High Court in exercise of certiorari or the supervisory jurisdiction will not convert itself into a court of appeal and indulge in reappreciation or evaluation of evidence or correct error in drawing inference or correct errors of mere formal or technical character. 9. In practice, the parameter for exercising jurisdiction to issue a writ of certiorari and those calling for exercise of supervisory power are almost similar, and the width of jurisdiction exercised by the High Court in India, like England Court, has almost obliterated the distinction between the two jurisdictions. While the exercise jurisdiction to issue a writ of certiorari, the High Court may annul or set aside the act, order, or proceeding of the subordinate court, but cannot substitute its own decision in a place thereof. In exercise of supervisory jurisdiction, the High Court may not only give suitable direction so as to guide the subordinate court as to the manner in which it would have would act or proceeded thereafter or afresh, the High Court may in appropriate cases itself make an order in supersession of or substitution of the order of the subordinate court as the court should have made in fact and circumstances of the case. Now 39, my lord, 39 and 40. Though we have tried to lay down broad principle and working rules, the fact remains that the parameter of exercising jurisdiction under Article 226 or 227 of the Constitution cannot be tied down in a straitjacket formula or rigid rule. Not less than often, the High Court would be faced with a dilemma. If it intervene in a pending proceeding, there is bound to be delay in termination of proceedings. If it does not intervene, the error of the moment may earn immunity from correction. The fact and circumstances of a given case may make it more appropriate for the High Court to exercise self-restraint and not to intervene because the error of jurisdiction, though committed, is yet capable of being taken care of and corrected at later stage, and the wrongdoing, if any, would be set right and the equities exercised in appeal or revision prepared at the conclusion of the proceedings. But there may be cases where a stitch in time would save nine. At the end, we may sum up by stating that the power is there, but the exercise is discretion, which will be governed solely by dictates of judicial conscience, enriched by judicial experience and practice wisdom of the judge. Now here, my lord, the appeal was allowed. Now, my lord, here the elaborately, my lord, in explicit term, my lord, delineate the power of the High Court under supervisory jurisdiction. Now, my lord, here in this case, my lord, since we have invoked the supervisory jurisdiction of this court, we have to show or satisfy this court that the apparent illegality committed by the learned appellate court, my lord. For that, my lord, we don't need to go to that extent that we have to reappreciate the evidence. It should be very apparent, my
That
lord.
will not be permissible also.
Yes, my lord. It must be very apparent, my lord. Now, my lord, since I have relied the judgment, my lord, I have to, my lord, rely the judgment of this Radheshyam also, because, my lord, to some extent, this case was, my lord, overruled, my lord. Otherwise, my lord, I will be liable for contempt, my lord, if I am not relying the
It is overruled.
not overruled, my lord. Only to the extent that, my lord, clarified that 226.
Some points are overruled.
Yes, my lord. Regarding 226, that order passed by the judicial order passed by the court is not amenable to the writ of 226, my lord, but under 227. To that extent only, my lord. Without taking much time, my lord, will find in actually the operating portion, my lord. If my lord allow, then my lord, I will read out some, my lord, appropriate paragraphs, my lord. My lord, para 5, 11, 18, then my lord, 28 and 29. That much paragraph, my lord. This is the Radheshyam case, my lord, reported in 2015-5, SCC 423, my lord. My lord, may kindly come to para 5, my lord, directly.
At page.
Page.
Okay, got it.
His 30 is very important. The operating part. Para 5, my lord, first, my lord, may kindly come to para 5, my lord. Paragraph 5, page number.
Got it.
431, my lord. 5, my lord. Thus, the question to be decided is whether the view taken in Surya Devrai, my lord, the judgment, I've relied, my lord, that a writ lies under 226 of the Constitution against the order of civil court, which has been doubted in reference order, is correct view. Only to that extent, my lord. Whether the court order, judicial order, is amenable to the writ jurisdiction under 26 or 226 or not. My lord, may kindly come to para 11, my lord. Para 11, my lord.
Yes.
It is necessary to clarify that the expression judicial acts is not meant to refer a judicial order of the civil court as a matter before this court arose out of the order of the election tribunal and not direct decision of this court, except Surya Dev Rai has been brought to our notice, where writ of certiorari may have been issued against an order of a judicial court. In fact, when the question as to scope of jurisdiction arose in subsequent decision, it was clarified that order of judicial court stood on different footing from the quasi-judicial order of the authority tribunal. Now, my lord, para 18, my lord. Just clarifying, my lord, the Supreme Court 226, the writ of certiorari, my lord, not the supervisory under 227.
Para 18.
Para 18, my lord. May I read that? While the above judgment deal with the question whether judicial order could violate a fundamental right, it was clearly laid down that challenge to judicial order could lie by way of appeal or revision or under 227 and not by way of writ under Article 226 and 32. Clarifying, my lord. Now, my lord, may kindly come to para 28, my lord. 28, 29, 30, that will suffice, my lord. Married, my lord, 28. We may also deal with the submission made on behalf of the respondent that the view in Surya Dev Rai stand approved by larger bench in Sahil Mahindra Sare Emporium to the Salim Advocate Bar Association, and on that ground correctness of the said view cannot be gone into by this bench. In Sahil, that reference has been made to Surya Dev Rai. The same is only for the purpose of scope of power under Article 227 as it clear from para 3 of the said judgment. There, my lord, only for the 227 it was referred. There is no discussion on the issue of maintainability of the petition under Article 226. Only on 226 the Supreme Court is explaining. Madam. In Mahendra Sari Emporium 2, reference to Surya Dev Rai is made in para 9 of the judgment only for the proposition that no subordinate legislation can whittle down the jurisdiction conferred by the Constitution. Similarly, in Salim Advocate Bar Association 2, in para 40, reference to Surya Dev Rai is for same purpose. We are thus unable to accept the submission of the learned counsel for the respondent. Accordingly, we answer the question refer as follow. My lord, the question was posed in para 5, now answering, Supreme Court is answering, my lord. 29.1. Judicial order of civil court are not amenable to reach jurisdiction under 226 of Constitution. Just clarifying now. My lord, 229.2. Jurisdiction under Article 227 is distinct from jurisdiction under Article 226. Now, my lord, here, 29.3, very important. Contrary view in Surya Dev Rai is overruled. That view was only overruled, my lord. So far as 226 is concerned, but not the 27, my lord. Regarding the invocation of the jurisdiction and the power which conferred to the High Court under 227, that was not touched by the Honorable Apex Court. Only to the extent that the judicial order passed by the court that cannot be amenable in any of that are not amenable to read jurisdiction under 226. That much, my lord. So now, my lord, here in our case, my lord, what apparent illegality has been committed, my lord? I will come to that now, my lord. But from our coordinate bench judgment, my lord, here the impugn order, my lord, is what's 9-8. My lord, the order dated 9/8/24, my lord.
9-8 in this proceeding.
Yes, my lord. The appellate court, my lord. 4/8 in. My lord will find in the impugn order 4/8/2025, my lord. Page number, my lord, will find in Annexer 39, my lord. Page number 39, my lord. Annexer 7.
Annexer 7.
Yes, my lord.
This is the impugn order.
Yes, my lord, the impugn order. My lord, what illegality the learned trial court has committed, my lord?
The IA was dismissed.
Yes, my lord, IA, the first, my lord, IA, which was for a restoration, my lord.
Is it gone?
Or admission of the appeal, readmission of the appeal. My lord, the finding is in para 5, my lord. Page number 40. Yes.
Okay.
My lord, para operating is page number 40. My lord, may kindly come to para 5, my lord. Para 5. May I read, my lord? In present case, the appellant has failed to adequately explain the reason for continue absence on all 3 dates. My lord, the court is seeking for the sufficient cause for 3 dates. Continue absence on all 3 days, especially prior to the 9/8/24. On 9/8/24, my lord, it was dismissed for default. Now the court is seeking explanation for all 3 days, especially prior to 9/8/24, mere attribution of blame to the previous counsel without any corroboration or affidavit from said counsel is insufficient. No daily particular of effort made post dismissal have been furnished, and the 123 days delay has not been convincingly explained. Now, my lord, here the learned court trial first appellate court is influenced by the earlier 2 dates also, my lord, which is, my lord, in fact not permissible under the law, my lord. It is well settled that the, my lord, sufficient cause has to be shown for the very date when it was dismissed, and for the earlier absence will consider to be deemed condoned. My lord, that aspect was, my lord, dealt by our own High Court, by the coordinate bench, my lord. I have furnished the, my lord, the judgment, my lord, by our coordinate bench. Here it says, my lord, for 3 days, my lord, adequate. And, my lord, the court is not considering the application on, my lord, justice-oriented, my lord. Justice-oriented approach must be there, my lord. And, my lord, it is well settled, my lord. In many cases, my lord, perhaps my lord may come across that because of the default of the counsel, the litigant should not make suffer, my lord. And this is the, my lord, the appeal. This is not a criminal case where accused has to be remain present for entire proceeding. And, my lord, that his, my lord, the action, it was not deliberate. Why? Because, my lord, initially, when, my lord, I have already given the date that initially he come to know when the people come to his the place where the status quo was granted. Then he initially come to know that it was vacated. Then immediately he filed an FIR. He engaged in new counsel. And, my lord, interestingly, after, my lord, rejection of this order, when this order rejected, my lord, the limitation period for, my lord, approaching the district judge under order 43 1 T1, my lord. T1, my lord. The limitation period is 3 years, my lord.
3 years.
Yes, 3 years, my lord. This is the judgment, my lord. My lord, from there I will demonstrate that, my lord, I was not deliberately delaying, my lord. It was not deliberate one, my lord, my absence, my lord. In fact, my lord, after coming to know and after rejection of this application, my lord, I immediately rushed before the district judge also. No doubt that has also been rejected. But in fact, my lord, the very initial order itself is, my lord, perverse, my lord. And it's illegal because the explanation has the sufficient cause has to be shown for the date when it was dismissed, not for the previous date, my lord. My lord, to fortify my submission, my lord, I will rely the judgment of our coordinate bench, my lord. Because the problem from the order itself, my lord, is very apparent that, my lord, it's written reason continue absence on all 3 dates. It's not saying on that particular date when it was dismissed. For that sufficient cause has not been shown. Court is not saying so. Court is being influenced by the earlier 2 dates, my lord. And that is not permissible under the law. My lord, But I'm relying the, my lord, on this count, my lord. I'm relying. Why I'm saying, my lord, this is
Name of
illegal.
the judgment is
GLT, my lord, 2018 for GLT 1184, my lord.
Nilab.
Yes, my lord. Nilab. Yeah, Chalia.
This I have.
Yes, my lord.
Absolutely, I got it again. You had given it earlier also.
Yes, given it earlier, my lord. I thought
very
it was becoming part of the record. It is already clarified by the, my coordinate bench in para, my lord. This is 2018 for GLT 1184 by the coordinate bench. Para, my lord, I will rely 7, 8, and 9, my lord. GLT 4, 2018 1184. But may I read para 7? 8 and 9. The second point which arises in this application is that when the suit was dismissed for non-prosecution, while order dated 2/5/16, whether the appellant is required to satisfy the court as regard the previous non-appearance of the counsel. The same situation, my lord. In this connection, this court is of the view that a satisfactory explanation is only required to be given for the date on which the counsel has not appeared and on which date the suit was dismissed for non-prosecution. In that respect, it is seen that the appellant has been able to demonstrate that on 2/5/2016, when the suit was dismissed for non-prosecution, the counsel was on leave and the name of the counsel is reflected in cause list dated so and so. Of this court, in the letter of the absence column, as the previous conduct of the appellant on the previous date was already condoned by the learned trial court by not dismissing the suit on previous date, even when the appellant was found absent on call. The conduct of the appellant on the previous date cannot be examined for the purpose of restoration of the suit, which was dismissed for default on 2/5/26. As good as sufficient cause was shown for non-appearance on the date. Under the circumstances, the learned trial court is found to have committed a jurisdictional error. My lord, it clearly says jurisdictional error, where my lord 227 comes, my lord. Error in relying on the previous conduct, my lord. It says relying on the previous conduct of the counsel in the suit because the said conduct of the appellant for remaining absent on call was not under scrutiny of the learned trial court on 2/5/26. Now, para 9, my lord. Therefore, following the ratio laid down by this court in the case of Nazrul Islam, Burburia, it is held that the learned trial court could have exercised power under section 151 CPC, notwithstanding the application made under order 9, rule 9 CPC, and moreover, having seen the non-appearance of the appellant on 2/5/2016 has been satisfactorily explained, this court is inclined to set aside the impugn order that is so and so passed by the learned civil just so and so, so and so. But here it says that is a that will be a jurisdictional error if you take into consideration of the previous date. When, my lord, the suit was not dismissed, the court, the sufficient cause has to be shown for the date when it was dismissed. This is the, my lord, law, my lord, and non-consideration on that aspect will be a jurisdictional error. Now it come under the jurisdiction of 227. So, my lord, and it is very apparent for that, my lord, I don't need to go for the other record, my lord. It's very apparent from the record, and, my lord, the learned district court was also affirming this order. He was influenced by this order also, because the learned appellate court, they cannot give new finding to that aspect. He have to give finding on this. Because, my lord, and my lord is well, my lord, aware that action which is illegal in its inception cannot be sustained because of the subsequent event, my lord. The consequent proceeding would become, my lord, non-est, my lord. So, my lord, if this is illegal, my lord, then ultimately the order passed by affirming this order will also go. And it is very apparent, my lord, the learned appellate court was influenced by the two earlier absences, which was not supposed to be explained.
In terms of this decision also.
Yes, my lord. In terms of this decision, my lord. And, my lord, my lord, the second line of argument, my lord, why this is, we have not deliberately, my lord, delayed in approaching the learned district court by invoking order 43.
Okay.
Rule 1T, my lord. That I will show, my lord. My lord, the limitation period is strictly governed by the limitation institute, my lord. Beyond that, out of that, my lord, there is no law govern the limitation period. Now, my lord, that aspect was dealt by the, my lord, pool bench of, my lord, Kolkata High Court, my lord, which was in fact, my lord, reported in 1988 SCC online, Calcutta 116, my lord. The three-bench judge, my lord. This aspect was dealt. My lord, why I am relying this, my lord?
Full bench?
Yes, full bench. Why I am relying this, my lord? Referring actually, my lord. Why? Because, my lord, that after the rejection or dismissal of the order by the first appellate court, I indeed has a, my lord, 3 years time limitation period. But immediately, within 30 days, we rushed before the district court, and the district judge has not even taken consideration our action, my lord. Has again, my lord, upheld this order and reject our application. Now, my lord, may kindly come to para 12, my lord. Allow me to read, my lord.
Para 12?
Para 12, yes, my lord. Here, my lord, the order 9 and rule 4 and 9, or 913 are, my lord, perimetria to this order 19, my lord. My lord, the statute of limitation is a disabling act, my lord, para 12, my lord. From here, my lord, I'm just trying to demonstrate, my lord, my conduct was not deliberate one, my lord. Once the litigant come to know about the dismissal, he immediately acted, my lord. It was not deliberate one, my lord. The statute of limitation is a disabling act. An action for claiming right flowing from various law is barred with lapses of time. As indicated in Limitation Act, limitation for action in law, therefore, has to be found within the four corners of the statute. In the aforesaid circumstances, it is appear to us that although the period of limitation for making an application for restoration of a suit of dismissal for default under Order 9 of Code is 30 days from the date of order of dismissal. My lord, same perimeter for dismiss for default of the appeal, my lord. The application for restoration or miscellaneous case arising out of such order under Order 9, when such miscellaneous case is dismissed for default. Now, my lord, again, if it is default, dismissed for default, is not governed by the provision of Article 122 of the Limitation Act. In view of the fact that expressly in term of said Article 122, the miscellaneous case arising out of an application under Order 9 is not attracted, and the period of limitation in such case should be governed by Article 137. 137 is 3 years, my lord. We therefore answer the second question by indicating that when the application made under Order 9, Rule 4, 9 or 13 of CPC for setting aside a suit dismissed for default in itself dismissed for default, an application under Rule 4 or 9 or Order 9 is made for restoration of the said application, the period of limitation for restoration of the said application, the period of limitation making such application for restoration is governed by Article 137 of the Limitation Act 1963, and the period of limitation is therefore 3 years. We may, however, point out in this connection that it appeared to us that when the period of limitation for making an application under Order 9 for setting aside an ex parte decree is only 30 days from the date of impugned order, it is highly inequitable to allow a party to avail a long period of 3 years under Article 137 of Limitation Act to make an application under Order 9 for setting aside the order of or dismissal of an application made under Order 9 for setting aside ex parte decree. It appeared to us that a party in whose favor an ex parte decree has been made cannot but suffer serious prejudice if the fate of the ex parte decree is allowed to hang indefinitely for 3 years by allowing the other party to make an application for setting aside the order dismissing the.
But it has not yet been amended.
Yes, not yet been amended, my lord. That is the interesting part, my lord. So, my lord.
But what the Calcutta High Court has said is correct, actually.
Yes, my
If
lord.
not 30 days, at least,
30
days and 3 years is too much of a difference.
Yes, my lord. That is what, my lord, I am saying, that we, despite knowing this fact, despite knowing this aspect, because he has now appointed a new council, despite knowing this fact, the council has not delayed. He immediately rushed to the district court, my lord. So, my lord, his cause that he's giving a cause that it was not because of his fault, it was fault from the council end. In 3 occasions, it was the council who didn't appear, and even he was not communicated to the appellant, my lord. Why he has not appearing? Only after the, my lord, the recall of the status quo order and the dismiss for default, then he come to know that okay, this order was recalled, recalled, and the appeal was dismissed. Then he, my lord, engaged a council, and as on that, within the time, my lord, he's before this honorable court, my lord, he's very unfortunate, my lord. May kindly appreciate, my lord, before the male court, before the village council, it was ex parte order, and before the appellate court, the court was not considered on merit, dismissed for default. He has again applied for restoration, that was rejected. And again, he rushed before the district court, it was dismissed. Now before this honorable court. My lord, the approach of the learned trial court will not, my lord, not a justice-oriented one, my lord. They will exercise their power. They too, my lord, illegality has been committed in not in justice-oriented approach, my lord. One must given, my lord, the opportunity of natural justice must be given. He must be given a right to establish his right on the merit of the case, in main case, not on these technicalities, my lord.
Anyway, so.
Yes, my lord. And my lord, sufficient cause has already been shown, my lord, will actually find in the order of the district court itself, my lord. All the law which has been relied and referred by the court has been quoted, but it has not been appreciated in true sense, my lord, for condemnation of delay, even for restoration. My lord, the Supreme Court, in the same situated case that it has been held that due because of the default on the counsel and my lord, litigant should not made suffer, my lord, for non-appearance of his counsel. All, my lord, I will, on that to expect, my lord, I will, my lord, because the sufficient cause has been shown, my lord, that it was because of the, my lord, counsel, it not because of the litigant, my lord. And my lord, I have just demonstrated that litigant is, and when he come to know about this thing, he acted, my lord, in every way, my lord, bona fide manner. And the 3 years delay, although it is not connected with this case, but why I am demonstrating it is, my lord, he was not doing it deliberately. Although there was 3 years time, my lord.
No, I got your point. I
Yes,
got
my
your
lord.
point.
Now, my lord, I will rely some
Alright.
judgments on my lord.
You already given some.
Okay, my lord, then otherwise, my lord, I was, my only, my lord, sufficient cause was before the trial court regarding the, my lord, the ground was for, my lord, because of the default on the end of the counsel, my lord, the litigant should not made suffer. Litigant must be given a fair chance, my lord.
This is a pointed judgment, this one.
Yes, my lord.
Of Nilab Chalia. We do this on our coordinate bench. Anyway,
Yes, my lord.
let's see what learned counsel.
Yes, my lord. Then
Should I proceed?
Yes, my lord. Yes, my lord.
Wait, please, Lordship.
You can reply, of course.
Yes, yes, my lord.
So let the
My lord,
first round be, no?
I must appreciate my learned younger friend that he has taken us through what had happened till filing of this petition under 227. Only one fact, my lord, I want to add is that during the after the dismissal of the suit for default, but I have applied for issuance of the land possession certificate that has been issued to me.
Okay.
Now,
LBC.
my lord, now, my lord, in his entire submissions for almost 1 hour, nothing has fallen from his mouth that there were jurisdictional error or that the court below did not exercise the discretion in a just manner. So, my lord, having said that, I must submit that both the trial courts, the first appellate court and the second appellate court, had exercised their discretion, considered the materials, and has come to a decision by exercising their discretion. Now, at this stage, we have to consider whether this honorable court, High Court, acting under 227 as a revisional court, can venture into all those issues. Now, my lord, there is no case made out that no jurisdictional there were any jurisdictional error exceeded or did not exercise that jurisdictional power as required by the law. Now, my lord, my submission here would be both the trial courts has exercised their discretion as per law, my lord. Now, this honorable court, by exercising under Article 227, can, being the only supervisory jurisdiction and not the appellate jurisdiction, can this honorable court be act like an
It is not
appellate?
a court of
Yes.
first appeal.
Yes.
It's just a revisional jurisdiction.
Yes, revision is
227.
because the first appeal, the second appeal, that provision has been exercised. Now, no, my lord, I need not repeat, my lord, submit, because your lordship has been very, very fluent about these provisions. My lord, the jurisdiction of this honorable court under 227. So it is only supervisory. It is not an appellate. Now, this revision petition is seeking or asking your lordship to re-evaluate
what facts and circumstances that has been considered already. They have not said that those decisions-making process were perverse. Nothing. Only thing is that those submissions could have been viewed in a different way. Now, my lord, both the learned trial courts, they have arrived by giving independent decisions, my lord. They have examined. In this impugned order, my lord, the learned district judge has considered everything. And in that earlier rejection order also, the court below had considered, he has arrived at an independent decision. Now, can those independent decisions arrive by exercising the discretion bestowed upon by the law can be substituted? That is I ask myself, my lord. Now, my lord, as far as the judgment and all, which has been referred at the end of his submission, he was just saying that the no explanations was given for the judgment which were quoted before the Honorable District Court, my lord. Now, my lord, from paragraph 15 to 17 or 18, my lord, Honorable District Judge has given his reasons, findings, why the cases cited are of use or of no use.
Okay.
Now, my lord, therefore, my lord, in the entire revision petition, there is no question asking that the decisions are perverse. The learned court below has acted beyond the jurisdictions or has not acted within the jurisdictions bestowed upon law. It only seeks to reappreciate of the facts by this honorable court. Now, my lord, therefore, the revision petitions seeks to invoke these provisions, whether those facts should have been considered in a particular manner and not in the manner which were arrived at by the court below. Now, my lord, my respectful submission is, my lord, my learned younger friend has taken us to that Surrender Rai cases and then Radheshyam, my lord. Now, my lord, my respectful submission is, I afraid, my lord, those cases are in fact in my favor. Surrender Rai Chaudhary, it gives overall broad protection that what can be done under 226. But we must also remember, Article 227 of the Constitution of India has a very, very big rider. Now, my lord, in Radheshyam case, my lord, of course, I do not have the judgment copy. In Radheshyam case, if I correctly remember, my lord, I will urge upon your lordship to go through the paragraph 30 and 31. My learned friend has relied only up to 29. Thereafter, my lord. So, my lord, it has specifically cast a certain jurisdiction, a boundary. Now, my lord, without
Radheshyam,
my lord. 2015, my lord, that judgment.
Radheshyam, this Radheshyam that he submitted, 2015 5
Yes,
HCC 4.
Radheshyam dilutes the Surrender Rai case, my lord.
Yeah, it is up to para 30. So I think your paragraph number you mentioned
yes,
would be something else. It won't be 30, 31. It will be something else, because it ends with 30.
Yes.
And so it must be something else.
Yes, I will just submit that.
You can check it.
Yeah. Now, my lord, let us come straight to the points, my lord. Now, I would like to, my lord, rely on the judgment of this coordinate bench, straight on the scope of 227, my lord. My lord, may I start with paragraph? May I just take yourself to paragraph 7 first? Because this is my submissions, my lord. I have relied on Kamala Devi versus Kusal Kanwar in this case, my lord. 2006 13 SCC 295. My submission was in support of his submissions. The Learned Council placed reliance upon the decision in Kamala Devi such and such reported in 2006 13 SCC 295, where it was held that a revision cannot be used as a substitute for an appeal which the petitioner failed to pursue within limitation. The order refusing to condone delay is a final order that results in dismissal of the appeal. The revision petition is liable to be rejected at the threshold. Now, my lord, may I just take this to paragraph 11 onwards, madam. 11, madam. May I read, madam?
Yeah.
The scope of interference under Article 227 of the Constitution is supervisory and not appellate. This court does not reappreciate evidence or substitutes its own discretion for the discretion exercised by the trial court oblique first appellate court, unless the order suffers from patent perversity, manifest illegality, and judicial error, my lord. Right at the beginning, my lord, I have submitted that there is no such averments made that this order suffers from perversity, illegality, or judicial error. Now, my lord, paragraph 13, my lord, 13. In the present case, the appellate court apparently had jurisdiction to consider the application for condonation of delay in preferring the connected appeal. The issue of sufficient cause in while considering the condonation petition is essential discretion in nature. The impugned order reflects the appellate court considered the grounds urged by the petitioner, and it had recorded the reasons for rejection. It has passed order in exercise of the discretion within the jurisdiction, and no jurisdictional infirmity is demonstrated in the impugned order. Paragraph 14, my lord. By filing this petition, the petitioner essentially seeks reappreciation of the sufficiency of the explanation for delay and reconsideration of the factual findings of the appellate court. Such exercise falls within the appellate forum, and it is impermissible in supervisory oblique revisional jurisdictions. 15. In view of the above, and in the light of principles laid down in Kamala Devi and Kusal Kanwar Supra, this court finds no ground to interfere with the impugned order in exercise of jurisdiction under Article 227 of the Constitution of India or Section 115 of CPC. The civil revision petition is dismissed as not maintainable, manner. Now, manner, exactly this is my case here, and manner, I would like to also rely upon 2022 4 SCC 181. Now, my lord, I'll read just two paragraphs, my lord.
2022.
22 4 SCC 181. I'll just read paragraph 15 and 16, my lord.
Just a minute. 181. No?
181, my lord.
No, 181.
Paragraph 15 and 16. Paragraph 15 and 16. May I read, my lord? May I read, my lord? Paragraph 15.
Go ahead.
Having heard the counsel for the parties, we are clearly of the view that the impugned order is contrary to law and cannot be sustained for several reasons, but primarily for deviation from the limited jurisdiction exercised by the High Court under Article 227 of the Constitution of India. The High Court exercising supervisory jurisdiction does not act as a court of first appeal to reappreciate, reweigh the evidence or facts upon which the determination under challenge is based. Supervisory jurisdiction is not to correct every error of fact or even a legal flaw when the final findings is justified or can be supported. The High Court is not to substitute its own decision on facts and this conclusion for that of the inferior court or tribunal, such as my lord, which is reported in 2010 1 SCC 217. The jurisdiction exercise is in the nature of correctional jurisdiction to set right grave dereliction of duty or flagrant abuse, violation of fundamental principles of law or justice. The power under Article 227 is exercised sparingly in appropriate cases, like when there is no evidence at all to justify or the finding is so perverse that no reasonable persons can possibly come to such a conclusion that the court or tribunal has come to. It is axiomatic that such discretionary relief must be exercised to ensure there is no miscarriage of justice. Paragraph 16, my lord. Explaining the scope of jurisdiction under 227 of this code, 27, this code in Estrella Rabari Das Estate Private Limited 2001 8 SCC 97 has observed the scope and ambit of exercise of power and jurisdiction by a high court under 227 of the Constitution of India is examined and explained in a number of decisions of this code. The exercise of power under this article involves a duty on the High Court to keep inferior courts and tribunals within the bounds of their authority and to see that they do the duty expected or required of them in a legal manner. The High Court is not vested with any unlimited prerogative to correct all kinds of hardship or wrong decisions made within the limits of the jurisdiction of the subordinate courts or tribunals. Exercise of this power and interference with the order of the courts or tribunals is restricted to cases of serious dereliction of duty and flagrant violation of fundamental principles of law or justice, where if the High Court does not interfere, a grave injustice remains uncorrected. It is also well settled that the High Court, while acting under this article, cannot exercise its power as an appellate court or substitute its judgment in place of that of the subordinate courts to correct an error, which is not apparent on the face of the record. The High Court cannot set aside or ignore the findings of facts of an inferior court or tribunal if there is no evidence at all to justify or the findings is so perverse that no reasonable persons can possibly come to such a conclusion, which the court or tribunal has come to. Number my learned younger friend has also relied on the paragraph 5 of the judgment or impugned judgment, where it is said that the reasons assigned for the delay, including the other dates. My respectful submission is that may be a broad submissions, which may also be correct. But then it does not say that the rejection was cumulatively based on 3 dates. The reasons for discretion of the rejection is based on his explanations for 9/8/23, 24. Absence on 9/8/24. Now, the other circumstances was just a contributing factor, in coming to his exercise of discretion, but those are not the specific grounds for which the misappeal was rejected. It was basically for the non-explanation, non-satisfactory of the explanation for 9/8/25, my lord.
All right.
So, my lord, in this entire judgment, now, my lord, the vested rights that has accrued to me after the dismissal has been clearly taken care of in paragraph 18 or 19, my lord. I have obtained land possession certificate that has not been challenged by him. That still subsist. No authorities has recalled or cancelled. So I am the legal owner on the basis of the land possession certificate. I have invested huge amount in developing the land. Well, in my objection petitions, I have annexed all those photographs also. The fact that I am cultivating, I have developed the land.
Right.
Now, my lord, the power, discretionary power to be exercised under Order 41, Rule 9, read with Section 5 of the Limitation Act. My lord, while exercising this, there is nothing which deter or prohibit the court to examine the entire conduct of the litigant, my lord, the overall conduct, situations. So, my lord, therefore, the explanations provided by the appellant petitioner is not acceptable. And my lord, in my Supreme Court and CRP 21, the coordinate bench, basically the ratio is that an application for condonation of delay requires a sufficiently convincing explanation to be granted, and an appellate court's discretion cannot be substituted by a supervisory jurisdiction unless there is jurisdictional error or high degree of perversity, my lord. Now, my lord, since I'm repeating for the third time, my lord, since this petition does not discloses, does not even have a word that this order suffers from perversity, illegality, or lack of jurisdiction, or nothing has been provided, my lord. So, my lord, this revision petition is liable to be dismissed at this threshold, as this is, we have to limit our outlook within the purview of Article 227. I respectfully praise your lordship that this petition, this revision petition may be dismissed with cost, my lord.
Keep it short.
Yes, my lord. My lord, I will reiterate the word which was used there in the Supreme Court in my lord, the Shyam case, my lord. The stitch on time save 9, my lord. My lord, the 3 deaths which were taken into consideration by the court, if that aspect has not been corrected by this court at this stage, that will be become, my lord, the precedent, and this will not be the only case which will come before this court. Multiple case will come because this needs to be corrected. And my lord, my learned senior counsel has submitted that we have never used the word illegality. My lord, in fact, from the judgment itself, I have submitted before this court. The learned trial court had exceeded its jurisdiction, and my lord has not appreciate the settled position of law. And my lord, the sufficient cause, it doesn't mean good cause, to my humble understanding. The sufficient cause has to be shown that for what reason on that day the counsel was absent, or in other case maybe my lord, the litigant was absent. For that sufficient reason has to be given, not a good reason. That this is not a good reason, this is a good reason, then the court will take into consideration. No. The sufficient reason has to be shown at why there on that day the counsel was remain absent. And that sufficient cause has been shown, which has been in mechanical manner, my lord. Perfunctly, my lord, the learned trial court has not appreciated the in this kind of cases, my lord, when there is a merit, my lord, and my lord, since my lord, senior counsel has submitted, the LPC has already been issued. In my case also, LPC was already been issued, which was again, my lord, cancelled. But during the pendency of the writ petition, my lord, since ex parte was there, my lord may see, my lord, to what extent, my lord, this I have been, my lord, I'm suffering, my lord. Male ex parte approach the writ court, my lord, because of the ex parte, the writ court has not exercised its jurisdiction. Now, my lord, I have contested, my lord, without any merit. Why, my lord, the learned appellate court will pass any status quo order, my lord? The status quo order was passed, my lord, and because of the negligent or, my lord, the conduct of the council, my lord, I have been made suffer. That is one of the aspect. And my lord, so far as the second aspect, my lord, I'm repeating again, my lord, despite there being 3 years of, my lord, limitation period, I have approached the court on time. And the second part is, my lord, every case has to be considered by its own fact and circumstances. My lord, here in this case, my lord, there is no any concept of, my lord, second appeal, my lord. Why? Because, my lord, the order which has been passed by the First Appellate Court is not a decree, my lord. Every case has to be considered by its own fact, my lord. If suppose, my lord, while preferring an appeal, being agreed by the, my lord, order of the village council, my lord, and I have been delayed in approaching the court and filing a condonation of delay. And if that condonation of delay was dismissed, then it will be get the flavor of, my lord, decree, and then the appeal lies, my lord, not the revision. But in my case, well within the time appeal was filed, during the pendency, my lord, it was dismissed for default. And that order is not at all get the color of, my lord, decree. So there is no any concept of, my lord, the first appeal or the second appeal, my lord. Miscellaneous appeal, which is specifically provided to deal with this aspect that has been invoked and being agreed, and no other remedy except, my lord, the 227. And that too, my lord, perhaps, my lord, I am able to, my lord, demonstrate that, my lord, the 3 deaths, my lord, if the 3 deaths was considered, and it was very much apparent that the learned trial court has exceeded a jurisdiction and has not appreciated the law as it, my lord, persisting as on that, my lord, as is prevailing as on that, my lord. With that, my lord, I will close my argument.
Like precedent and sympathetic consideration is not a ground for interference under Article.
And my lord,
27.
my lord, I will not read out this judgment, but I will rely, my lord, on the sufficient cause, my lord. That on sufficient cause.
Submit.
Yes, my lord. I will just submit.
Just
Paragraph, my lord, I have also written the 3 judgment, or, my lord, just on sufficient cause. That's it, my lord.
That okay, that will be useful.
Yes, my lord.
It has to be resolved.
Yes, my lord.
I heard counsels for the Mr. Tony Burton, learned counsel for the respondent. Arguments concluded. Judgment is resolved.
Yes, ma'am. There was an interim protection also, ma'am. No third party interest has to be clear.
Okay, the interim order by so and so date shall continue till pronouncement of the judgment.
Deeply obliged.
Obliged.
Short break. Just fold up. The final hearings, will it be possible? So we'll finish the bail, then quickly go through the orders. The final bail, this criminal appeal and criminal revision. I don't know. Let's see.
Lordship, it's been almost 1 month, Lordship. And moreover, without this record also, it can be delayed, Lordship. Because I have already furnished this search sheet also, Lordship. There is no need of the, in fact, record, Lordship.
It involves application of 37.
Yes,
Because section 27A is involved.
yes.
So in any case, we have to peruse the materials.
Yes.
All the why is it taking so long, madam? Please get it.
The registry, normally when the direction is being given, your lordship, the registry sends a mail to the concerned.
It has to be procured from which court?
UPR.
Lordship,
Yeah,
It's very nearby, but then I don't understand why.
Lordship, this is very prejudiced to this accused person, Lordship. Moreover, this arrest of the accused person is very illegal, Lordship, in double FIR, in one case. This is serious, Lordship, misdeed from the authority.
He has been in custody for anyway. The case is at the stage of trial. Must be at the stage of trial.
Lordship, even if it is trial, Lordship, there are 2
No, I'm just asking. It is this case in which you are seeking bail is at the stage of trial.
Yes, Lordship. Right. Because I have already examined Lordship.
We issue a reminder for the, urgent reminder.
Yes.
And along with a status report of the trial, how many witnesses have been examined?
Yes.
all that. Because he is annexed, but still, we
Yes,
should
sir.
have see the official
The
records
last
also.
order annex is of
Also,
March.
because 37, if it was 37 was not there, then perhaps we
Lordship,
could have,
yes,
but
in fact.
otherwise it's necessary
Yes.
because 37 determination has to be made.
And
So-
it was actually filed on 8.
Also, learned counsel for the petitioner and Madam, additional PP
Yes, sir.
for the state of Arunachal Pradesh. Please. The petitioner is seeking bail in connection with NDPS case number 32 of 2023, within bracket arising out of Chimpu PS case number 15 of 23, bracket close, under section 21C, 21C, 21, 27A, 29 NDPS Act. Full stop. The case after being charge sheeted, the case, so and we write it like this: the case was charge sheeted and presently stated to be at the stage of trial before the learned special judge UPA,
Yes, sir.
right? Papampur district. Full stop. The learned the learned additional PP submits that the scan TCR has not yet been received. In this context, the learned counsel for the petitioner submits that it's been a month for awaiting the TCR, scan TCR, and that the petitioner seeking bail is in custody since 2023. Full stop. As the determination on the next paragraph, as the determination on the section 37 NDPS Act has to be made,
Lordship, it's been 1 month and 20 days, Lordship.
it would be prudent to peruse the official records. Accordingly, issue an urgent reminder for the scan TCR, along with a brief / concise report on the stage of the trial. Full stop. The scan TCR should comprise the scan copy of the case diary, charge sheet, depositions, if any, and other relevant documents. List on.
Cannot at least a
Lordship,
week.
after 1 week.
After 1 week.
Did be on
29.
Friday, next Friday or Thursday? Today is Wednesday. Next Friday or Thursday?
Next Friday, your lordship. Yes.
Is it okay for you?
Lordship, on Lordship, 3 of June. Friday, 3 Monday.
In August. 7th of August.
3rd August may be too early
Lordship, it's only taken 2 months only. It's going to be.
because again another
It's
date may.
29.
Huh?
On 10th, your lordship. 10th of August.
Please make sure that it's.
Your lordship, normally the TCR
Regi-
is being procured by the registry, your lordship.
So yeah, scan TCR. The registry shall do the needful.
Lordship, on 10, I have already fixed with the Lordship.
Okay. You
11, Lordship.
11.
Let it be
okay.
11.
Deep.
Item number 12.
The last occasion, TCR was followed. However, it's available. Then what again?
This is also UPA. TCR not yet received. As per the last office note, 28th. Okay. It's yesterday's office note. So Trial has progressed a lot, it seems, in this case.
I have been told that the cases of the present accused and the other accused has been segregated and
Segregated, yes. There has to be, one is absconding, nevertheless. You're Mr. Gatso. Your good name, please. Learned counsel for the petition and additional people. Jimmy. For the state. As per office note dated 28/7/26, scan TCR is called for from the Sessions Court UPI is not yet received. Full stop. He is in custody since 6/4. Investigation is already completed so far.
He's
No,
in custody.
No,
he
can't
was
be.
18/5/26, Your Lord.
18/5/26.
Yes, page number 25 is the.
Okay.
He was granted, he was on bail on the earlier occasion. Your Lord.
Thereafter, call for the scan TCR, you write like previous one, Sessions case 219. 219 of 2013. Arising out of DMK, PS case number 30 of 2013. Comprising case diary, charge sheet, you just like for, right.
On 12th, Your Lord.
Same like before. 12 is all.
Item number 13.
May it please, my lord. My lord, in this matter, one of my colleague will be appearing from principal bench. He was supposed to appear.
Okay, let him join. We'll take it up after some time.
Lordship.
Item number 14.
Lordship, if I may. Lordship, this is a pre-arrest bail in connection with the case number 46 of 2026.
Right.
The sections are 61 to 318 BNS. My lord, you will find the FIR at page number 16, my lord. Basically, the gist of the FIR is that, my lord, the complainant received a phone call from an unknown person saying that that person has some gold to be sold. So, without verifying, they met at a place, Gumto Gate, the Assam Arunachal border. They met. She purchased 10 lakhs worth of gold without any verification from an unknown person. And also, my lord, now she does not know this person. However, she tracked the person through the vehicle used by the accused person to come to Gumto Gate. So, my lord, my humble submission is that, my lord, this whole FIR is concocted, my lord, and based on false facts, my lord. Because if my lord will see the annexure 2, page number 17, my lord, therein we have annexed the Zimma order of the vehicle.
Okay.
Now, what the informant is saying is that the accused person, the unknown person, was identified through that vehicle. However, my lord, this vehicle is not registered in the name of the accused person himself, my lord. It is of someone else. So, accordingly, the learned court had granted Zimma to the original owner. So now, my lord, if the vehicle was not registered in the name of this unknown person, my lord, the whole FIR, the narration made in the FIR is false, my lord. That this person was identified through that vehicle number. It is not possible, man. More so, my lord, on the last day, the interim protection was granted by this
Yes,
honorable
I've
court.
seen that.
And my lord, the accused person has appeared before the IO and given his statement as well, my lord. My lord, we are praying that if his statements are recorded and if he has cooperated with the investigation, my lord, we are praying that
Without much verification, buying gold worth 10 lakhs is also very
is also
peculiar.
not
It's not a responsible conduct
Yes, my lord.
to oneself. Anyway, so
We
ma'am,
have received the CD, Your Lordship, and the accused has given its statement. However, it seems that his custodial integration is not necessary, Your Lordship.
may not be necessary.
Yes. So the entry may be made absolute otherwise.
He has denied completely
Yes.
in his statement. Anyway, make it absolute. Also. We have some, we can take part of the order from this, okay? Yeah, 20 last order, you can take para 2, you can take para 2 and 4. No, para 2 you take stop. The case arose out of an FIR dated 21/4/26, lodged by one Biri Rupchi, alleging that she got a phone call from an unknown mobile number 789-6057-143, asking her to buy gold from that person. And accordingly, she went to Gumto Gate, where she found two persons. And after having a brief conversation, paid a sum of rupees 10 lakhs for the gold. Full stop. Subsequently, upon checking the gold, found it to be fake. Full stop. The petitioner was granted interim bail on 21/7/2026, pursuant to which he is stated to have appeared before the IO. Full stop. The learned counsel submits that the allegations are false and concocted, and that the petitioner has been falsely implicated. Full stop. The case diary scans is here. This is the original case diary.
No, Your Lordship.
The scan case diary is received. Full stop. The statement of the petitioner has been recorded, in which he has completely denied the allegations and strongly contended about false implication by two persons named Kasem Ali and Usman. Full stop. He has stated details in support of his contention about false implication. Full stop. The learned additional PP fairly submits that as the petitioner has appeared pursuant to grant of interim and his statement has been recorded, perhaps his custodial detention may not be essential. Full stop. I have considered the matter in the given circumstances. The interim so-and-so is hereby made absolute, subject to the condition that he shall cooperate with remaining investigation and shall not hamper or tamper with evidence. Since it's a scan case diary, we did not say return back.
Yes, sir.
We did not say that. Disposed of. Disposed of.
Item number 13, pass over matter.
Yes.
May I please, Lordship? Lordship, there was a slight misunderstanding since in item number 13 and 15, both my name is reflected. 15, my learned friend will be appearing from Gauhati. So
now,
basically, these
13 and 15 are same.
Lordship, it's different, different FIR.
Okay.
It is
So now we take up
13. Yes, Lordship.
Which is different.
So it is connected to cyber crime PS case number 22 of 25, Lordship. Lordship, before entering into the merit of the case, Lordship, in fact, when this bail application was filed before this honorable court, the accused was languishing in the custody for almost 83 days. Now that during the pendency, that 90 days period is already over, Lordship. And so far as the instruction from the, registry is concerned, they have informed me that the accused charge sheet has not been filed by the investigating officer.
So this is with regard to which accused?
Which regards to
Because this is a AB.
No, this is a regular bail application, Lordship.
So in this case, the statutory period is already over.
Over, Lordship. So may I pray that the instruction may be taken?
No, in that case, you will be entitled to bail. When was he arrested?
Lordship, on last occurrence, it was called for, but we didn't receive the Lordship.
He was arrested on 28 April 2026. 28 April.
Just calculate it. 28 April is 4.
Yes.
28 April, 28. May,
Today is 29, Lordship.
28. Because 90 days and 3 months are different.
Lordship.
Calculating month is very easy.
Lordship.
Date to date.
Lordship.
Say today is 29.
Lordship.
29th, 1 month is 29th August. But 30 days, again, it will be, sometimes it will be 30 days, sometimes it will be 31 days in the month. So that's different. So you just calculate, I think it should be, if it is
91 days.
91 days, then his right has started. Right has started.
Lord,
When can you take the instructions? Tomorrow you take?
after Lordship.
Take it tomorrow only.
Tomorrow, Lordship.
If possible, take tomorrow. The learned counsel, your good name, please.
A Tatak.
A Tatak, learned counsel for the petitioner, submits that the petitioner seeking bail who was arrested
28/4.
on 28/4/26. It is from the, as you know, we all know that it has to be calculated from the date of remand.
Yes.
First remand.
Lordship.
First remand.
Yeah.
And 91st day or 61st day.
Lordship.
And as far as investigation is still going on. And in the meantime, he's completed the applicable statutory period of 90 days. Full stop. The learned PP undertakes to take instructions regarding the status of investigation. List. Tomorrow we have DB also, but after that
Lordship, it can be taken up as last.
we can. Let's fix it tomorrow.
Matter of
In case there's exigency, don't be. We can sit because statutory bail has some urgency, right? Please take the instruction. List the matter tomorrow.
Deeply obliged.
Matter number 15.
He has not yet joined.
My lord, may kindly take up item number 3 and 4. These are arising out of the same FIR.
Oh, these were pending, no?
Pending.
Morning. Oh, I see. Same FIR.
Same FIR, madam.
You are appearing
I'm appearing in item number 3 and 4.
3 and 4.
First 3, my lord may take up. My lord has gone through the FIR. In fact, it was fixed day before yesterday. But my lord will find the FIR at page number 25. My lord.
Yes. The prime allegation, prime accused is alleged to be one Rishiraj Purpose,
Yes, my lord.
right?
Yes.
And some allegations against his wife also. Okay. Now,
I'm not named in the FIR, or in fact, there's no whisper about me in the FIR. my
okay,
lord.
you are not named in FIR.
Not at all,
You are Mridu Pallav Hazarika.
my lord.
Huh? Mhm. Go ahead.
In fact, my lord, in this case, the petitioner is a duly licensed proprietor of IMFL. It's a wholesale, my lord, warehouse. My lord may kindly have page number 22.
Diary has come, no? Diary has come.
Yes, no, sir.
Otherwise, no, it's okay. Keep it. Keep it.
I have got to the Lordship.
This is also the diary for all the 3 matters. All the 3 matters.
In fact, the case diary was called for in respect of the item number 15.
15, Lordship. But in item number 15 also, her name was not in there.
Same in that diary. Anyway, okay, we'll come to that. Yes.
My lord,
Come to
kindly
that.
have page number 22. That is the license which is authorized to the petition.
So it starts like that. He had the license for IMF.
IMFL, my lord. And that's a wholesale warehouse. Page number 22 is the license which I have obtained, my lord. And in fact, after obtaining the license, my lord, during the COVID pandemic, my lord, the petitioner was going through some financial constraint in running his business, which is wholesale warehouse. My lord, in order to, in fact, to keep the business operational, my lord, he was looking for some financial backing, in fact. And it was during that period, he came in contact with the present alleged accused person who is named in the FIR, which is my lord, Rishiraj Borkotov. And my role is very limited, my lord. I had a farm. He has taken over my farm on rental basis for a period of 3 years, my lord. My lord, may kindly have page number 42. To that effect, my lord, we have executed a general power of attorney as well.
Page 42.
42, my lord. The contents would be at page number 43, my lord. This is the power of attorney which I have given to the named accused in the FIR only for the purpose of running the firm, which is in my name. My lord.
With some investments.
Yes, my lord. And that was only for a period of 3 years, my lord. Now, thereafter, my lord, in fact, we had some differences. Since the main accused, in fact, yes, there was some default in payment of the rent, as well as, in fact, there was a default in payment of the renewal fees of the license as well.
Yeah.
And to that effect, we have issued a notice to the alleged accused person. If my lord may kindly have page number 48, that is a notice which I have issued against the alleged accused person, my lord. This is the acknowledgement of the speed post, and my lord will find the content at page number 49. This is with reference to the agreement that it's so and so executed between Devajit Raj Kowa and Mridul Pallav Hazarika and yourself under the jurisdiction of Sivsagar concerning the IMFL wholesale license with the locking period of 3 years. It has been observed that certain terms and conditions of the said agreement have not been duly complied with as mentioned below. Irregular payment of rent, no purchase or business activity carried out by you to that. After several discussions, you have conveyed your decision to discontinue from this business during the current month and to clear all dues on or before 30th October 2025. Accordingly, based on your confirmation, we have prepared the final settlement statement, which is attached herewith for your kind perusal. You are requested to kindly settle all outstanding dues on or before 30th October 2025 and proceed with the formal resolution of the agreement. We appreciate your cooperation, so and so. In fact, there was a due. That is the reason we have issued this notice. Otherwise, apart from that, my lord, I have no connection or I have no knowledge about the informant who has lost their fire, my lord. And that much is my role. I had a business transaction with the alleged accused person, and that was only for a
That
period.
also ran into difficulties, then
Yes,
you
my
issued the notice.
Yes, my lord. Now, we are in the verge of filing a suit for recovery of the money as well. But since, because of this transaction, perhaps, my lord, a notice under 35(3) has been issued by the investigating authority. So that is the reason I have a genuine apprehension that I would be wrongly entangled in this case and my liberty would be at stake, my lord. That is the reason, my lord, I'm seeking for some protection. My lord, the notice, my lord, will find at page number 51, my lord.
Yes, I've seen.
In fact, I have enclosed a medical certificate also, but I'm not pressing on the medical certificate, my lord. Because prima facie, my lord, there's no case against me at all. Only for a reason that I have some business transaction with the main accused person. That is the reason a notice has been issued against me, my lord. Therefore, I humbly pray that, my lord, since the case diary has been received, my lord, this matter can be disposed of with, by protecting me, my lord.
And the next one?
Next one, my lord, the other partner, my lord.
The same.
Other partner, same partner.
Basically, the contentions are similar.
Yes, ma'am. Same contention, and he is also one of the partner of the license holder.
I'll take the submissions on these two, because every petitioner's case may be different.
But why I'm
Don't you need this? You need not need this?
I have already finished with
You've gone. First, let us,
why I request submitted for taking with this with item number 15 lordship. In item number 15 also lordship, their name was not in the FIR lordship, and their
FIR, as we know, it's not an encyclopedia, but I mean,
I'm appearing for the petitioner item 15, my lords.
wait, just hold on. No?
Very well.
We'll complete.
Kindly come to the page number 9 of the item number 15 lordship.
No.
Then I will lordship.
You'd like to make the submissions together on the CD?
Yes, lordship.
Together. Then should I hear him? Hear his submissions, 15?
Yes.
And then together you'll take? Then I can do it.
Otherwise,
yes.
Yes.
The learned public prosecutor will make common submissions, right?
Very well.
So therefore I will proceed to hear you. Okay.
My lord. My lords has already gone through the FIR on the last occasion. The allegation
I went
is
to the FIR, yes.
the allegation is that the informant was cheated by the principal accused for setting up an alcohol plant. Now, how I am connected with the entire matter, Your Lordship, is that I am an interior designer by profession. Now, this principal, he entrusted 3 works to me for interior designing purposes. One was for a residential property, and 2 of them were for a restaurants, Your Lordship. And the total amount was around 2 crores 73 lakhs 89,000, which the principal accused was supposed to pay me in lieu of my labor, my designs, as well as for materials, Your Lordship. Now, the work for all the 3 projects were underway, and from the accounts of the principal accused, I have presently received an amount of rupees 96 lakhs 17,920. That amount, my lords, is declared income, and whatever income tax is also due, I have paid income tax. Certificate from the chartered accountant is on record. My lord, now I have been issued a notice under section 35(3), principally because, Your Lordship, there is a money trail leading from the account of the principal accused to my account, Your Lordship. I cannot deny the money trail. I am not denying. I am willing to participate in the investigation. My only apprehension is that since money has indeed come from the account
into your account, so
Yes.
you may be arrested.
Yes, and similarly,
I understand.
my lord,
Mm.
Your Lordship would like to
So-
have the certificate of the chartered accountant. That is at page number 57, my lord.
Page 57.
57.
Hmm.
This is to certify that based on information and other records produced before me by Mrs. So-and-so, the amounts credited to the SSC's bank account in connection with interior work contracts were as follows. During financial year 23-24 from Rishiraj Borkotoki, rupees 14,72,676. From RB Enterprise, rupees 1,66,450. During financial year 24-25 from Rishiraj Borkotoki, rupees 24,14,196. From Vaibhavam, this is one of the restaurants of the principal accused, rupees 37,86,534. And during financial year 25-26, from Rishiraj Borkotoki, rupees 16,77,764. And from Shrutimala Datta, that is his wife, rupees 1,300,000. So total amount of rupees 96,17,920 has indeed come into my account from the accounts of the principal accused. But this, Your Lordship will see, a substantial portion of these receipts were utilized towards labor charges, purchase of materials, and other project-related expenses on behalf of clients. Accordingly, total bank credit does not represent the actual income of the SSC. Only the net service stroke contract income earned has been disclosed in the respective income tax returns, and applicable income tax has been duly paid. Note, for financial year 25-26, income tax return will be filed within next month, and tax will be paid on same. This certificate is issued at the request of the SSC based on the records and information explanations produced before us for lawful purposes only. So, my lords, the dilemma which the petitioner is in, Your Lordship, is that she had offered her services, professional services, to this person who is now accused of a crime, and she had received certain monies for her services, and without, I mean, as a professional, she did not have any way of determining beforehand what the source of the money is, if it is at all, even if it is proceeds of crime, Your Lordship. So at this stage, she is willing to participate wholeheartedly, whatever is required in the investigation, but she's praying for some protection. And while this bench was on vacation, my lords, the Itanagar bench, some matters had come before the principal bench, identically placed persons, Your Lordship. Amounts had been
I've
transferred.
seen. That was submission was made that day
Yes,
also.
my
So,
lords.
but
So
I
that
wanted
is-
to have a look at the case diary, so we
Yes,
fixed
my
it today.
I'm really sorry I could not appear physically, my lords. There was some
It's
extremity.
okay, no problem. No, I should be sorry. It's okay. These facilities should be available for everyone.
I'm deeply obliged.
Okay. Yes, now we can proceed with
Proceed.
the process. I'll keep this with you. You've already gone through it. Okay.
Submitted by the petitioner in item number 14, Lordship, item number 15, Lordship. They said that she is the interior designer and received aggregate amount of Lordship 96
Professional income.
professional income. Is at page number, Lordship, page number 9, paragraph 9, Lordship.
Of the?
Of the bail application.
Okay.
Item number 15, Lordship.
Okay.
But as per the case record, Lordship, case diary, Lordship, I mark flag mark the Lordship, the finding of investigation. There was 62 lakhs of undisclosed Lordship amount is there, Lordship. The money trail is there, Lordship. So see this with regard to the item number 15 only, Lordship.
Mhm. Okay. No, this 62 lakhs, is it, it is outside the, this is beyond the amount indicated by the CA certificate?
Yes, Lordship.
Hmm?
Yes, Lord.
Anyway,
Kindly come to the Lordship express report page number, Lordship. Front page.
62 lakhs. Hmm?
First page, Lordship, from the beginning, Lordship. First page, Lordship.
Of?
The case diary, Lordship.
Yes, first page.
I kindly
Status report.
kindly see the Lordship. Here is the item serial number 7, 8, and 9, Lordship.
Mm-hmm.
The observation of Lordship. ILM. Since this is the initial stage, Lordship.
Total money in question is about 34 crores for running. 34 crores.
Yes,
Is that so?
Yes, ma'am.
34 crore, Lordship. 32 crore.
Yeah, as per the informant.
Yes.
Hmm. Just a minute, no?
This 96 was proportional fee, Lordship, and there the undisclosed Lordship, 62 lakhs, Lordship, in the account of Lordship, this applicant, Lordship.
Okay. Yeah. This is your submission. Hmm.
And the Lordship, statement of IO is at first page, Lordship.
I've seen that one. One clarification I would seek from the learned counsel who's online, that the prosecution submits that an amount of 62 lakh something was into the account of the petitioner as per
My
the
lord.
money. It's called the money trail.
My lord.
So the CA certificate, you must have heard my query, right?
My lord.
So the CA certificate, this is covered by the CA certificate.
My lord, in fact, it's more than 62 lakhs. It's actually 96 lakhs, which I have received. And there are
Okay.
still more monies due from the principal accused to me because I have put in my labor and materials. Even I have not been fully paid for my services, my lords. It's not actually 62 lakhs. I've received more.
Anyway, so. And what about the other, his contention that the
Since
IMFL only?
the item is also not FIR, and there may be some Lordship, there may be monetary also. That's why Lordship notice was issued, Lordship. So at least Lordship, without parenting the Lordship case diary, Lordship into the and for the investigation. It's in the item number 16, Lordship, also, Lordship.
In other words, the prosecution is indicating money laundering of the money.
But in my case, prima facie,
Yeah.
I have demonstrated the case that there's
I've written down.
no case at all. There was only one transaction, and that was in respect of my farm. And that farm was taken on rental basis for a period of 3 years. And to that effect also, we have some issues, in fact. There are certain dues which is yet to be paid. So I have there's no case or there's no whisper at all. So therefore, I deserve at least a protection in case if they're seeking for some more instruction from the investigation officer.
Yes. Okay. Okay. I'll take some time to go through it. Huh? I'm not dictate it here.
My lord, just one more aspect. The principal
Yeah,
accused
you can complete.
principal accused are also on bail, my lord.
Yes, I'll go through those orders also.
My lords, my lords.
So, are they the principal accused? Borkotogi is also on bail.
Yes,
My
my
lord.
he is on bail.
He's also on bail.
And
Yes,
there
my
are some other judgments. My lord may kindly have those judgments. I have one
Principal
copy of the judgment.
The orders are at, my lords, page number 36 and 40, your lordship, for both the two principal accused, husband and wife.
The prosecution is not moved for Rishiraj Borkotogi, the prime accused. He's on anticipatory bail.
He's on regular bail, man. He was
Of the trial court process.
Okay, for the trial court. Trial court. We have not moved for any cancellation of bail on that. Anyway, so I'll go through it.
Grateful.
Inside, I'll give you a bit. This is a scan, right? Okay, I get it. Huh? Yes.
deeply obliged.
Item number 3 and 4 also, I think. Is it
3, 4, 3, 4, and 15.
Grateful, man.
Deeply obliged. man.
Love just with my points.
Item number 16.
We'll do the order matters and then this MAC, this mediation, that's hearing, difficult. I think hearing matters won't be possible. So, learned counsel, if anyone waiting for hearing matter, you need not wait. You can take a date, perhaps. You can take a date and try to do it in the coming days. To save your time. Yes, item 16 lodge. Item 60. To follow, there was already anybody for the insurance company. Not anyone appearing for insurance company. None appears on behalf of the appellant, as well as for respond number 1 and 3. Let's stop. Respond number 1 / insurance company. Let's stop. Fresh steps were taken upon respond number 2 by speed post. Full stop. And as per office note dated 28/7, service report is awaited. Full stop. This is the matter after 3 weeks on a date to be fixed by registry. Case record is received.
Yes, sir, there.
Is there?
Yes.
TCR is available.
Understood motion.
I think that I forgot upon that. Yeah, I gave it on that person. Thursday it will be there. It is not fixed now today or I don't matter. Okay, the motion. I forgot to.
I think so understood motion there.
Unlisted, we'll take up the this motion matters.
May I please, my lord? Bail application filed in connection with Sagali PS case number 2/2026. The herein accused was arrested on 6/1/2026, my lord. The trial is now pending before the special court at yeah, my lord.
Lordship, in this matter, Lordship, here the applicant is not disclosed his criminal antecedent, Lordship.
My lord, he is already in the custody, judicial custody.
Nowadays, there is a judgment. No, it is necessary. I mean, there is judgment of. I think it came.
Not man.
There's a notice. No, the notification was pursuant to that judgment.
Yes.
There was a judgment.
Kosal Singh, Lordship.
Yes. Huh?
Kosal Singh.
Yeah. Judgment. And it came later part of 25 or early this year. And on the basis of that, there was a notification.
To the Kosal Singh judgment, Lordship.
If there is anything which is not in the petition, you file an additional affidavit then.
Yes, my lord.
Better to be clear on the facts. No?
My lord, here the petitioner is the elder brother of the accused person. So the petitioner have no any criminal institution, my lord.
He doesn't have.
No.
No other criminal.
No, my lord.
Then it's okay.
But he had to
No, any.
Lordship, as per the notice.
Oh, he has to mention this. That's
My
true.
lord, in that case, we'll
It's
find
a
additional.
for rejection also, Lordship.
Okay, well, that's true.
Additional fine.
No, give him a chance since yes.
In the meantime, my lord,
Actually, it will be it may be ministerially rejected at the time of filing. But anyway, since it has come heard, so it is submitted by the learned counsel for the petitioner that the petitioner seeking bail has no previous criminal antecedents and he would like to file an additional affidavit regarding the same. Prayer is allowed. We list the matter on when should it file? We file it quickly.
Tomorrow.
Tomorrow, let's fix it on Friday. Friday or Monday? Friday or Monday.
Matter is that
Notice has to be issued.
my lord, accused is in custody, judicial custody since last 209 days. So he's having some exam, my lord, which has to pay is and 9th of August, my lord. So therefore, we come before honorable court. We have already seeking 2 bail application before the learned trial court, but it was not considered. On the ground that we have not enclosed documents, the exam, sorry.
Notice has to some arrangements can still be made for allowing him to give the exam without granting interim bail also. That is also possible. I have experience. But notice should we issue but let him file the additional affidavit. The question of maintainability. Otherwise, you file it day after tomorrow.
Day after tomorrow.
Much.
Item number 33. Unlisted motion matter.
Thank you. Is it connected with that matter which we heard in the morning? Mr. DK Das had appeared, no? Got it.
Maybe, my lord, the council.
I think probably it is connected matter. But we have to just check the number. That was SIC. No, I don't think so.
So it is connected with item 7, Lordship.
Item 7.
Lordship. An order has already passed.
Connected with item 7, which learned counsel had appeared, no, in the morning. Item 7. Okay, we'll pass common orders, then that order which is half done. 18. We have not given the date, right? Okay, together we'll dispose it of.
Item number 34, unlisted motion matter.
Up to the motions I'm rising because that's on the. Yes.
In petition. On the basis of settlement, madam, on the basis of settlement at 27/2026, madam. And the matter was pending before the exam FC Naharalan.
We follow the usual course.
Yes, my lord, it's perhaps it's between husband and wife, my lord.
Yes, yes.
Because 85 is to cruelty against the husband, by the husband in relative to the women.
Do we get the copy on the?
My lord, we have to call for the, my lord, since charge sheet has been filed.
Yes, yes.
We have to
That's why I'm
call
asking.
for the trial court record.
We follow the.
Yes, same
standard
procedure. Yes, ma'am.
And we'll keep the proceedings on hold. Keep it on hold. It'll take a couple of days to.
Yes, I'm praying for the interim, madam.
Huh? Yes, yes.
Interim time.
Yeah, the proceedings will be suspended.
Yes, ma'am.
And in the meantime, we'll get the records. Heard your good name, please.
A. Dalbong.
Planet Counsel for the petitioner. Planet Counsel for the petitioners who are stated to be husband and wife who are joined seeking who are joined in invoking section 528 BNSS for quashing of GR number 779 of 24 arising out of Itanagar Women case 41 of 24 pending before the court of the learned JMFC Naharlagun. Good stuff. It is submitted that upon completion of investigation, the case was charge sheeted and presently pending before the said learned court. It is stated and submitted that the petitioners, being husband and wife, have entered into a agreement dated 20th July 26, settling their disputes and seeking an end to the criminal proceedings. In this backdrop, the present petition has been filed. Copies shall be furnished to the learned additional people. Call for the scanned TCR of so-and-so case from the learned court below. Next paragraph. In the circumstances, further proceedings in GR so-and-so shall remain state till the next returnable date. List the matter after 3 weeks.
3 weeks, madam.
On a date to be fixed by revision.
Yes, madam.
If it does not get listed, you make a mention.
Obliged, madam. Deeply obliged.
Item number 35.
My lord, it is in fact criminal petition, my lord, also a joint petition, my lord.
It is also a joint petition.
Yes, my lord. My lord, offense involved is POXCO, my lord. But my lord,
POXCO.
the LS victim and my lord, both husband and wife, my lord.
You will take it now.
Ah.
You will take it now.
So, without any further order, my lord, extension order, the registry is not allowed me to take step.
Okay.
Therefore, my lord, simple one word.
Lord Counsel submits that he could not take the steps of service within 3 days as directed by this court. and praised for allowing to do so.
Within 1 day,
The prayer is allowed. The petitioner shall take steps of notice upon respondent number 2 within
1 day.
5 days. I'll be liberal with you.
Okay, thank you, Mila.
My lord, in item number 19, my lord,
Yes.
there is an interim order, my lord, that may be continued.
Yes, no problem.
This matter may be fixed for tomorrow, my lord, since we will be considering it, my lord. Considering the matter, my lord. In fact, petitioner, my lord. My lord, I don't know.
Tomorrow, I don't know how many matters, when we'll be free
My
for
lord,
the
if-
division bench.
My lord, in that case, my lord, let matter may be fixed tomorrow, and if there is no time, then then it may be fixed next week.
My lord, after week matter may be fixed, my lord. I'll come with my lord, all the argument, my lord. There is no urgency otherwise also. This is only civil revision
We are
petition.
conceding it. That means you are settling it.
Not only the simpliciter, my lord, considering. There is another aspect where
Let's fix it on Monday. That'll be good. Friday, okay. Friday. See, he has to be in a hurry. So
My lord, Friday on which date, my lord?
Friday will be 7. No, not next week. This week, Friday. 31st.
My lord, 31st,
This Friday.
I'll be having difficulty because I am going to Gauhati, my lord.
Achha. So then Monday, madam. Let it be on Monday.
My lord,
Accommodate.
my lord, not Monday, my lord, Tuesday, my lord, 4th.
Tuesday is again division bench. Again,
My lord, I'll be back. I'll be back on Monday, my lord.
Tuesday.
Tuesday, my lord. Much of it. Till such time, my lord, the interim.
Interim will continue. It's there.
Deep.
Also, item number 21, criminal petition number 1, 78. Also, requiring kindly taken up to me. 51 of the
Okay.
Thank you, sir.
Monday.
Along with, also item number 30 and 31.
Okay.
Your Honor, in item 21, I am Your Honor, in item 21, I have serious objection. I need some more time. So this morning, I
It's
filed
connected, madam.
wakalat number.
Is it just connect? He's already left him. You talk to him.
Okay, on Monday, then I'll appear. Kindly record my name, Kodapa, in item 21.
Yeah, but kindly talk to him because then we'll fix another date. You talk to him.
My lord,
Another date.
my lord, if I may, my lord.
The learned counsel for the petitioner prays for fixing the matter on Monday. However, the learned counsel appearing for the respondent. You are appearing in
Yes, respondent number 2.
respondent number 2 in
Yes.
criminal petition 178 of 2026. Objects to the same. He suddenly made the mention and went away.
Yes.
Very strange manner.
Very strange. So that is not acceptable.
Appearing for respondent directly. State is also there, madam. He is appearing for the private. Today perhaps he entered.
Yes, sir. This morning, I filed my wakalat number.
The learned counsel further submits that he has filed the wakalat number only today. How much time you want?
At least 2 weeks. Yeah.
Stop. Let it be on Monday, this Monday, next Monday.
Okay.
Is it okay for you? You tell him.
Okay.
Because you objected.
Yes, yes, I have objection. Even he heard, but he left deliberately.
I'm saying that. And anyway, 10th August. 10th August.
Great.
My lord, if I may, my lord. My lord, if I may.
Yes.
My lord, item number 17, my lord. Today is listed for orders. My lord, can
Yes.
this matter be fixed on Friday? It is for issuing of notice and admission of the appeal, my lord.
Well, no problem. Only admission of the appeal.
Only admission of the appeal, my lord.
Actually, my lord, earlier the application for delay of condonation was disposed of, and then now matter was
I
is for suspension, my lord.
Suspension.
Oh, that's
There was 2 IA. One is for my lord condonation of that was disposed of, my lord. Delay has been condoned, and it is
just
for-
give me the file once. Criminal appeal, we should have some.
Item 7.
24 appeal. It's not yet admitted.
It's not admitted, my lord.
It's not admitted, my lord. my lord, it
But
took some
only,
time for.
only, my lord, for serving of the notice, my lord, it has taken time. And later on, my lord, service was
Just pass
complete.
an order on.
Yes, madam.
Not possible.
Yes, madam.
Take 2 minutes.
Yes, madam.
That's a POXO is there, no?
Yes, madam. Notice has to go in both IA and, my lord, criminal appeal, but first it has to be admitted, my lord. Matter has not been admitted.
Heard and so. The instant statutory first appeal in criminal law is preferred PSG. What PSG will be which district?
Pasighat, Pasighat, my lord.
Pasighat SC POXO case number 20 of 2022, whereby the appellant was convicted under 354 IPC read with section 10 POXO Act